Hey.
Morning, Your Honor.
Morning. And these are the cases of State versus Christopher Throgmorton. Have I pronounced that correctly, sir?
Yes, sir.
All right.
Actually.
Have case number 46-DO3-1807-CM-1737, 64-DO3-1807-CM-1721, and 64-DO3-1807-CM-1755. All matters are scheduled for bench trial. They'll be tried, of course, individually. The state appears by its special prosecuting attorney. Can you identify yourself, sir?
Micah Cox, Your Honor.
And defendant appears being self-represented and have bench trials scheduled. I believe also there are some pending motion in each file filed by the defendant. I believe it's 4C, a request for motion to dismiss. Court has advised or has read all of the briefs and all of the motions. We probably should address those issues. Shall we incorporate your arguments as a global argument for all three cases, or would you like to address those case by case?
I believe a global argument for all three cases, Your Honor.
I would have to agree, Your Honor. It would seem that the 1737 triggered the recusals in 1721 and 1755. So, I don't know. Fruit of the poisonous tree is necessarily the right terminology, but something to that effect. 1755 and 1737 essentially have nothing to do with 1721. They were sort of lumped together in a recusal in 2018, and they've pretty much been handled all as a trifecta since then. So, any issue that would apply that I've pretty much brought up in that motion would apply to all three cause numbers at this point, pretty much because they were lumped together in 2018.
Mr. Throgmorton, excuse me, what would you care to add that is not contained in your memo and your motion?
I have a good bit of supporting documentation for all of that. A lot of it's reflected in the docket. I would like to point out that I'm not just pointing out the 4C time as it would be calculated. I think that time in combination with the recusals and the basis for the recusals has created somewhat of a cumulative prejudicial effect. For instance, any one of these cases could have been handled on their own and reached disposition by now if they weren't all attached to this 1737 case. So, I mean, I'm not just raising an issue on the time. The recusals and the basis for the recusals has proven since to be false. I believe that I went through a long time of waiting on the clerk's office to locate another special judge over and over and over. And I understand that if I requested a recusal, I would be responsible for that time that was my fault. But I can't reasonably expect that the clerk's office is going to wait months at a time in between special judge appointments. As well as, sorry about that, obviously the amount of time that's went by since then, these recusals have sort of affected the way that I'm able to defend myself with the cases individually. I mean, for instance, I'm pro se, I'm fully expected to do back-to-back-to-back trials on all three of these within 2 days. So, just the culmination of the time that has went by and because of why the time has went by. I mean, I can prove that there doesn't seem to be a conflict of interest for the reasons that have been outlined in those recusals. The conflict of interest seems to be with me, but nobody will formally claim that, and the reasons they're given have since been proven on other dockets to be non-existent. Mitch Ficus has a conflict of interest in all these has been proven non-existent. In this very courtroom, just 2 months ago, Mr. Otis is still filing in this courtroom, even though this court has claimed a conflict of interest with the city of LaPorte as well at this point.
That's why I'm here.
Mr. Ficus' son, Will Ficus, is currently charged in this very courtroom. The Christina Espar, John Espar, Mr. Ficus relationship that is quoted in Mr. Espar's recusal as well as John Lake's recusals and such. According to Christina Espar, there was not a conflict. She was the DCS attorney.
Judge, I'm going to object at this point. He's getting way outside what the issues are and getting into a lot of hearsay stuff.
Your
I don't
response?
think it's hearsay at all, Your Honor. Every bit of this is proven by a positive or a docket.
Well, let's stick to the time frames. That's really the crux of your 4C motion here. So,
Not necessarily. I believe that my...
well, I think it is. So let's stick to the time frame.
Does the time accumulating for a specific reason matter?
You can continue with your argument, sir.
Okay. Is there anything that the court needs me to elaborate upon? Because it would seem that all these recusals are reflected on this very docket. So those aren't necessarily, that's a fact, I presume, at this point. The reasonings why these recusals have taken place are on the docket. All this information has been provided to the court. And I tried my best to move these cases along. I contacted the clerk's office quite regularly, to the point that I'm fairly certain they were a little bit annoyed with me. But, I'm a pro se litigant, so the clerk's office basically treats me like I don't know what I'm talking about. So my efforts to move these cases along were basically futile. But it's to my understanding that the state and the court is responsible for making sure that I have, due process, like my trial is supposed to be kept track of by the courts and the state, not only just me, the defendant. So I don't believe I bear the majority of the responsibility as the state would insist for this time. There's no reasonable way that I could expect months in between, every judge in Northwest Indiana has a conflict of interest because of a political stance by one person. It sounds like my cases have become strictly about local politics.
Again, that's why I'm here.
And, Your Honor, if I may take a small pause here, I would just like to make sure that's on the record. I'm very nervous, so I apologize if I've prepared the best that I can for this. I'm not going to lie. I understand we're here today and we're doing this, but 3 trials back to back to back. I made my best attempt, but this was a lot to prepare for.
Certainly.
I was exhausted before I even got here, and I don't know that there's much that I could really present to the court that I haven't in my motions to dismiss these cases, one of which has never been ruled upon at all. The other 2 were dismissed by a judge who recused as a conflict of interest. So, and the state has provided no written response really to anything up until this most recent motion. So, I'm a little confused myself, which is why I asked for the autism advocate to sort of explain exactly how some of this is conflicting with Indiana Code and rules of trial procedure and such. But it's, there's a lot that I don't really understand how the court hasn't handled this already, sua sponte, based upon what's on the docket. The docket speaks for itself, that is. And there's no way for me to seek out a way to have a lot of this addressed because it was in the hands of the clerk's office. And to the best of my research, which includes speaking with the governor's office, the Office of Judicial Qualifications, the State Court Administration Office, the Attorney General, there is no process to challenge the lack of action or a negligent care of duty for the clerk's office. I've tried. I believe last time I was in front of you, you yourself acknowledged that, you know, this court doesn't have jurisdiction over the clerk's office. I'm not really sure who does, but if something gets messed up on the docket, I don't know how to challenge it. And
Well, and if you'll recall, that's why I cautioned you about the perils of self-representation when you decided to dismiss your public defender and didn't want a public defender from Indianapolis to come up and
if I
take
may,
the case. So let me hear from the state, because we need to move on.
some
All right.
circumstances have changed since then. There's been new orders that affect how this court process is playing out. So I didn't really foresee that I wouldn't be allowed to have a family member here with me as moral support. Nobody from the press is allowed in the building. This isn't streamed live, like I'm to the understanding that court proceedings are supposed to be. Like, I'm very nervous to even be in the building. And based upon the past 2.5 years of how this has been handled, no offense, Your Honor, but my faith in the justice system has been a little shaken. You know, without the public to at least be concerned with these proceedings or have access some way.
Well, perhaps I can
I
renew
don't
your
know
faith.
if I feel comfortable moving forward now that we're in this, you know, now that we're here.
Well, here we are, so we need to get them done. Why don't you be quiet for a moment? Let me hear from the state in response. Thank you.
Thank you, Your Honor.
All right.
Mostly I rely on the contents of my motion. Just to summarize, I believe there is some time chargeable to the state. It's not enough to allow him for discharge under criminal rule 4. I also pointed out the different time frames when the Indiana Supreme Court has suspended the tolling on Indiana criminal rule 4. And outside that basic argument of there's not enough time chargeable to the state, I believe he's acquiesced to this trial date by his failure to lodge a timely objection and have a hearing on that motion. Because here we are on the day of trial, and this issue is being raised, and he didn't even file the motion until months after the trial date was set. Thank you, Your Honor.
Thank you. Well, I don't think your motion is well taken, Mr. Throgmorton, on all your cases, so I think we state his timely proceeding, especially when you factor in the issues regarding the pandemic and the 9 or 11 months that we've been stayed. So we'll proceed to trial today. Parties ready for trial?
I'm ready, Your Honor, and I have the witnesses here for...
Let me interrupt you for a moment, and then I believe when we last met at our hearing, we had agreed we were going to try a particular case first.
The battery 1737.
I believe that was what we thought. That is
my understanding is my notes said we were going to do them in the order they were filed, so I had the resisting law enforcement and trespass, then the battery, then the intimidation.
Normally I would do that. I thought we had agreed as to acquiesce that Mr. Throgmorton, I apologize, sir, suggested the rest of the cases may fall in line if we took care of one. I'm not sure. But in any event, it is the state's to try. I assume you're prepared on all 3 cases?
I am, Your Honor.
Proceed, Your Honor. May I clarify something real quick so I make sure I understand? He's done some calculations of the time. I have 2 questions. Has the court done an accurate calculation?
I have.
And is that available today, or are we just going off of what his is? And secondly, the recusals that I outlined and how basically they seem to be political activity by a judicial officer to strip me of my due process rights.
Again, why I am here.
Is that motion well taken?
It is not.
Okay, so all these recusals, all right, and is there a way that I can have that? What do I need to do?
I'll include in my order a denial of your motions. You can take it up to the Court of Appeals.
For that, or I would like to appeal that specifically.
When we're all through, you may have the option to appeal.
I may.
All right.
I'm not in the jail.
All right. So, counsel, which case would you like to try first?
Your Honor, I have the most witnesses and the most people here on resisting law enforcement and trespass, CM 1721.
Well, let's proceed on that case then.
Thank you, Your Honor.
Your Honor, I would like to make a note for the record. I was not prepared for 1721 first. I'm prepared for 1737 first. As the court is correct, we did agree to. And the docket will reflect that.
Since we're going to do all 3 in the same day, or same 2 days, hope you're prepared for all 3 of them.
All right, but we're not doing 1737 first?
We'll do 1721 first.
All right, Your Honor, is it possible that I can I go ahead and get some more time? I waive any foreseen time because I'm not prepared to proceed today in this fashion.
What's your response, counsel?
It seems to be incorrect, so
He's wanted a trial. I've seen all his postings on the internet where he's demanding a trial, so here we are to do a trial. I'm ready to do a trial.
One at a time, gentlemen.
I'm ready, Your
I'm
Honor.
going to respond to that. All my posts have reflected that I'm fully expecting the 1737 to be tried first, based upon the fact that I believe if it is dismissed or I'm found guilty of that time being attributable to the conflict of interest that arises in the 1737, I believe that may jeopardize the 1721 and the 1755. So that's specifically why I requested it at the last hearing that I was in front of you with.
Appreciate that. We'll proceed on the
If you had an issue
1721.
with it then, I would have objected to that, Your Honor.
We'll proceed on the 1721. Counsel, you'd like to make an opening for, give you 5 minutes?
Yes, just briefly, Your Honor. This case involves 2 counts. It's resisting law enforcement and trespassing. It involves the date of June 5th, 2018 at 801 Michigan Avenue. That's the LaPorte, city building is what we would call it in Stark County. There was a Board of Public Works meeting that day. Mr. Throgmorton, the defendant, was there, as well as the fire chief, the city attorney, Nick Otis, and various police officers. At that Board of Public Works meeting, Mr. Throgmorton had an order from another judge for some documents. He demanded those documents be provided. He'd been previously told by City Attorney Nick Otis that he would get those documents, but not right at that moment a few days prior, and not that particular day. Mr. Throgmorton then goes upstairs to Kareem Fitzgerald's office, who's the assistant for both the City Attorney and the Human Resources Department. He demands the production of these documents for quite some period of time. He's told that they're not denying giving him the documents, they're just not ready at this time. The city attorney is working on it. He's very insistent, very forceful with his demands. He's asked to leave multiple times by the legal assistant in that office. The police officers show up, both Julie Smith and Jennifer Lewis. They interact with the defendant, Mr. Throgmorton, ask him to leave multiple times. He continues to refuse to leave and becomes more and more animated. They eventually attempt to place him under arrest for trespass, refusing to leave the property. He then begins to struggle with the officers in the back corner of the office, refusing to give them his hands. It takes those 2 officers, as well as 2 backup officers, Officer Drangmeister and Officer Loza, to show up and gain control of the defendant and get his compliance and handcuff him and take him into custody. I think the court will hear from the evidence. It's a fairly straightforward case of resisting law enforcement by struggling with police officers engaged in their duties. And he was trespassing in this public building by creating a disruption that allowed people not to be able to perform their job duties for the other members of the public, and we'd ask you to find him guilty of such, Your Honor.
Thank you. Mr. Throgmorton, you care to make an opening statement to the court? If so, you have 5 minutes.
I would, Your Honor.
Please go ahead.
Here, I have a quotation from Judge Alavisos that I would like to read from the April 10th, 2018 transcripts.
I would object, Your Honor. That was never provided in discovery.
It's a public record, Your Honor.
Well, it's also just an opening statement, so
Right.
go ahead.
In any case, you could judicially notice it's sui sponte because it's a public record. Anyway, Nick Otis claims in these transcripts that I was issued a trespass order, essentially along the same logic that Mr. Cox here has elaborated upon. And Judge Alavisos asked, how essentially does one get trespassed on the most sacred of public lands, City Hall? Your Honor, I intend to present to the court today, hopefully, that in 2015, I had an experience with a officer of the jail, and it made me somewhat uncomfortable. I have a diagnosis that backs up these feelings and everything. Essentially, I have a problem with physical contact. I don't necessarily touch people or go out of my way to do so, and I'm not a big fan of people putting their hands on me, even if it's affection or whatever. I essentially tried to make a documentational kind of instance with the local police department about this to sort of avoid it happening another time. And I wasn't trying to get this individual arrested or anything. I was simply trying to make a report. In that instance, my My interaction with the officers did not go well. I sought to file a complaint the next day. When I arrived, one of the witnesses, Julie Smith, was under the impression that I had been arrested the evening before. So when I showed up to make a complaint, she basically told me that it wasn't the first time that somebody had been arrested and showed up to lie about an officer in a false complaint. I ended up physically carried out of the building that day because I insist on filing a complaint, which I believe is my right to do so. This is petitioning my government for redress and their agents. I walk from the police department to City Hall, which is where I meet the city attorney at the time, Rebecca McQuaid. She essentially has a conversation with me where I describe the situation that I encountered and schedules an appointment to take my complaint. I later give my complaint. Pocket knives that are referenced as being thrown at me by these police officers at the police department are mentioned in this complaint. She asked me specifically about these pocket knives. I showed them to her in open palms to display size, which she's inquired about. Put them back in my pocket, schedule my appointment, come back, make my complaint, come back 4 days later to pick it up, and I'm made to sign a confidentiality agreement. And I'm sent to the prosecutor's office, given the runaround. Every time I try to go back to the city, all of a sudden, the police show up. I take about a 4-month break and I start studying FOIA law and public records and what right to information I, as a citizen, have. I go back February 5th of 2016 and February 9th of 2016 and attempt to file a public records request for any information that relates to this complaint and the outcome of my complaint. That's where this whole trespassing accusation arises. I'm in City Hall and they've locked the building down so that they don't have to interact with me, but they just let me walk around the building. Very confused as to why there's nobody there, as a public official, to get any answers from, and I'm trying to make contact with the Human Rights Commission in regards to this matter. I'm trying to make a complaint, simple, write some information down on a piece of paper and have it evaluated. Police officers are there trying to coax me out of the building. I end up arrested face down on the sidewalk outside of City Hall after they told me to leave for trespassing. They tell me to leave, I leave the building. I end up arrested, for trespassing then. It's dismissed by the state 4 months later, in June of 2016, as holding no probable cause. It would seem to me that I'm only trespassing at City Hall if Julie Smith, who's a witness, is present in the building. Other than that, I've been in that building hundreds of times, literally hundreds of times. I've literally refused to leave and not been charged with trespassing. But if I have a court order for public records from a local judge, I went through the entire process, and when it came to an end, I was accused of trespassing on public property. So essentially, what I intend to show this court is that either A, the Rebecca McQuaid is only an agent of the Department of Law and no principal has exercised any control of authority over her, or B, I would love to argue out that public property is entrusted to fiduciaries of the public. The public is the owner. The public officials are there and they're not trespassing because they have authority to be on the property, essentially by taking their oath of office. Trespassing requires numerous elements. I believe there's 5 in the jury instructions, 7 in the Indiana Code, as well as outlined in Lyles v. State. That's from 2012. The principal-agency relationship has not been established at all. And I understand the lawfulness of the denial of entry is not an element of the crime that the state has to prove.
You need to wrap up your opening argument, sir.
But I believe that I'm only trespassing simply because I'm seeking accountability. Every bit of this is First Amendment protected activity. I think the fact that all of these judges have recused because of this, or I think a lot of these judges have recused because of the complications of these cases and the different protections under the First Amendment that they, in actuality, trigger. Even litigation has been held to be a form of political expression, NAACP v. Button. This is all First Amendment protected activity that elected officials haven't essentially banned me from that building. Attorneys have. And there's no reflection anywhere that they were ordered to do this. All public records, all police reports both insinuate that Rebecca McQuaid and both Nick Otis acted on their own accord. They are under no direction from the city to have me arrested for trespassing. And obviously, if I'm not trespassing, I'm not committing a crime, so I'm not resisting a lawful arrest.
Thank you.
Thank you.
Call your first witness.
Thank you, Your Honor. State will call Nicholas Otis.
I think it might be best, we have testimony from council table. Are you Mr. Otis?
Yes.
Sir, would you have a seat at the chair at the council table for me? Before you do, though, raise your right hand. When you approach the council table, I'll place you under oath. You swear or affirm, under the penalties of perjury, the testimony you're about to give will be the truth.
Yes, Your Honor.
Thank you. You can have a seat right there. Will you state your full name and spell your last name for the record?
Yep. Nicholas Todd Otis, last name Otis.
Thank you.
Do you want him to keep his mask on or off?
It's fine by me, unless there's an objection. He can have his mask off. If counsel, you're comfortable, you're in the closest space. All right.
Can you pick me up all right here?
Yeah. Sir, will you please state your name and spell it for the record?
Yep. Nicholas Todd Otis, Otis.
And what is your profession, sir?
I'm an attorney, licensed in Indiana.
And how long have you been an attorney?
Since 2008.
Do you work for a particular firm?
I do. I'm a partner at Newby Lewis, Winsky & Jones law firm here in the court.
Do you also have a position with the city of LaPorte?
Yes, I do. I'm a city attorney.
And what is your role as the city attorney for the city of LaPorte?
Yep. I became the city attorney in the fall of 2017, either October or November of 2017. And I provide legal services to the various city departments and the city council and the board works, and just generally any legal questions that any of those departments or boards have.
Do you have an office at one of the city facilities?
Yes, there's an attorney. Well, at that time, there was a specific office for me as the city attorney.
And where was that office located in June 5th of 2018?
It was located at City Hall, which I believe is 801 Michigan Avenue, LaPorte. It's on the second floor of City Hall.
And that's in LaPorte County?
That's correct.
Did you also have an assistant in an adjoining office to that office?
Yes.
Who was that assistant?
Kareem Fitzgerald. And she was my assistant as the law department. She was also the assistant to the HR director as well.
Okay. So I want to talk to you a little bit about June 5th, 2018, around 9 that morning. Was there some type of public function that morning?
Yes, the City of LaPorte Board of Public Works has meetings twice a month on Tuesday mornings at 9 o'clock. It's the first and third Tuesdays.
Okay. Do you know someone named Christopher Throgmorton?
Yes.
How do you know him?
He regularly attends public meetings at the city, makes frequent public records requests, probably at this point since I've been the city attorney, I guess around 50.
Object, Your Honor, unless I have a definition of frequent.
Overruled.
I just said 50.
Overrule the objection. Proceed.
Over what course of time?
This isn't cross-check, sir. You'll have a chance.
I'm just making sure I understand what he's insinuating.
Take your notes. I'll give you a chance at cross-examination, sir.
Mr. Throgmorton frequently, before the pandemic, would show up at City Hall, refused to leave. We had many interactions with him where the police had to get involved. This predated me as the city attorney. I know that the city had, from reviewing the incident reports, had to, the police had to get involved quite a few times to force him to leave the City Hall.
Do you see the person known to you as Christopher Throgmorton in the court?
Yes, he's sitting at the defense table right now.
That's this gentleman right here?
Yes.
Okay. So on that morning of June 5th, 2018, around 9 a.m. when you had this Board of Public Works meeting, how do you come into contact with Mr. Throgmorton, the defendant, at that meeting on that day?
Yes. So the Board of Works is made up of three individuals, the mayor and then his two appointees. And so they run the meeting, and then various department heads are typically at the meeting. This depends on the day what department head would be present. But I'm always, I shouldn't say I'm always present. There's a Board of Works meeting literally going on right now, and somebody else is covering that meeting for me. But I attend those meetings regularly. Mr. Throgmorton would come sometimes to Board of Works meetings, but more typically he would come to City Council meetings, which are on Monday nights. I noticed that he came in late for the meeting. I don't remember the exact time, but it was after the meeting had started and most of the meeting had taken place. And at the end of the meeting, Mayor Prince, Mark Prince, who was the mayor at the time, said, "Any other business?" And generally that's directed towards the other Board of Works members. Right. Mr. Throgmorton spoke up at that point and said, "I have business," something to the effect, "I have business with the city," and Mayor Prince informed him that the public comment was earlier, and that was his opportunity to speak. And Mr. Throgmorton continued to talk and said, "If you don't give me documents, I'm going to go physically take them."
Now, these documents he's referring to, was this another public records request?
Yeah, it was. He'd made at that point not as many as I said, now 50, but he'd made 5 or 6, 7 public records requests. He filed a lawsuit alleging that we had illegally withheld police reports and attorney-client privilege information. So we had a hearing on that in circuit court, which is upstairs in this courtroom. We had produced those documents for an in-camera review for the judge to look at, say, this is the legal basis that we believe that we're properly withholding these documents, make a decision. So the judge ruled that the police reports were law enforcement recordings and ruled that we had to turn them over. We didn't agree with that. The order that he was referencing had come out the Friday before, so like 3 or 4 days before that.
This order you're mentioning, did you see that first on June 1st, 2018?
I think it was a Friday, so if that was June 2nd, I think it was the day that I became aware of it.
Okay.
I think that sometimes orders would get issued, and then on Odyssey or my case, you don't get it till the following business day, for example.
Did you have a discussion with Mr. Throgmorton, the defendant, on June 1st about receiving the order and you eventually provided him the documents?
I think it was June 2nd. It was a Friday. I don't know if that was the 1st or the 2nd. So the Friday before, 3 or 4 days before, he showed up at City Hall demanding the documents, and I advised him that based off of my reading of the order, we had 30 days to either produce the records, appeal, or file a motion to correct it.
When he's referencing at this Board of Public Works meeting to go get the documents, do you believe that to be him referencing those same documents?
Yes. Yep. He referenced the court order during that comment in the Board of Works meeting.
Okay, so after he makes this comment, what do you see the defendant do?
But he also said that the city owed him $5 million, and right at that point, right around then, the meeting was adjourned. And he had some sort of communication with Julie Smith, who's a police officer for the city of LaPorte. She was at the meeting, and then he made his way upstairs. The city hall's 2 floors. He made his way upstairs to the 2nd floor where my office was and where Green Fitzgerald, my assistant, was.
Okay. Was there also someone at the meeting that was involved with the fire department?
Yes, Andy Snyder, who's the fire chief. He was the president. This is the fire chief. There's usually something with the fire department that's on the agenda, so he usually attends.
Okay. And after you saw the defendant go up the stairs towards your assistant's office and your office, what did you do?
I realized there was nothing that Kareem was going to be able to do to help him with what he wanted that day. So, based off of the prior interaction that I had had with him on Friday, 3 or 4 days before, I advised Julie Smith that there was nothing that Kareem was going to be able to do for him, and that he needed to leave. I was concerned that, based off of Kareem's prior experiences with him, that he was going to attempt to either intimidate or harass her, and there was nothing as the legal assistant that she was going to be able to do to answer his issue.
And just so the court's clear, Julie Smith at that time was the assistant captain of the LaPorte Police Department?
He may have been the assistant chief at that time.
Okay, assistant chief.
Yes.
Okay, so do you then see Julie Smith go up in the same direction as the defendant?
Correct. Yep. There's a stairwell right when you enter City Hall that goes up to the second floor, and at that time, the Green's office was right there at the top of the staircase, and then my office was immediately to the left.
So just so it's clear for the court, does the defendant, Mr. Throgmorton, work in LaPorte City Hall?
No, he's not an employee.
Does he rent a room there?
No.
Does he have an office in that building?
No.
Okay. Does he have a greater right to be in that building than anyone in the general public?
Not to my knowledge, no.
Okay, so no contractual interest in the building whatsoever?
Not that I'm aware of, no.
This would have been during business hours when he went up into that area?
Correct, yep.
Earlier, you also mentioned that your assistant, Corinne, is it Corinne or Corinne?
Corinne,
excuse me. Corinne also worked for the Human Resources Department?
She was the assistant to Jen Holt, who was the HR director. So she provided, again, assistance to me as the city attorney and then to Jen Knoll. For example, new hires, she would kind of do all the onboarding paperwork, that type of thing in her office.
Would she have sensitive health information type documents in her office?
I certainly would expect so. There's people that fill out, there's probably HIPAA protected information. I mean, she does all, like I said, all the onboarding right there, and she would frequently use my office to kind of do that with new employees. So she would keep, I know there were sensitive employee files.
Now your assistant, Corinne, how large would you say her office is?
It's pretty small. I mean, I would guess 8 by 10 tops, yeah.
Is that the only area she has to fulfill her work duties?
Yes.
Pass the witness.
Sir, do you have some cross-examination of this witness?
So, Mr. Otis, you mentioned that there's a history of me refusing to leave
Yes.
City Hall. Do you know if I have been convicted of trespassing based upon any of this history? Are these merely accusations by the city, or is there some sort of proof of me being guilty of criminal trespassing in the past?
There's been multiple instances where various city officials have advised you to leave and you refuse to leave. I'm not aware of you being convicted of trespassing.
So none of those previous instances were held to meet the criteria in order for you, like, Your Honor, if I may, him insinuating that I'm refusing to leave is very similar language to basically saying that I was trespassing. So
This is your opportunity to question the witness.
Okay, so there's no history that you know of where I've been convicted of trespassing based upon
Not that I'm aware of.
history of this. Okay. And you said the officers in numerous instances before were there to force him to leave.
I don't know about force you to leave. I mean, literally the Friday before, 3 or 4 days before, you showed up in Annette Leffler's office, who's the mayor's assistant, executive assistant.
I believe he did
Reviewed like workforce.
So I'm asking if he.
Well, let him finish his answer.
I don't need all that extra information of why.
Let him finish his answer and then ask another. Will you be quiet for a moment? All right. Let him finish. If you don't like his answer, you may follow up with further questions. Court reporter can only take down one at a time, so gentlemen, please remember. You can finish your answer, sir, unless you were through.
No, that Friday before, he showed up in Annette Leffler's office. I was coming in not because of you. I had an 11 o'clock meeting with the mayor and the various members of the project team for the city at the time. You were in her office. You had showed up wanting these records. I advised you of the city's position on it. I advised you that you needed to leave. You refused to do that. Annette, I requested that Annette contact the police because you were refusing to leave her office. 4 officers showed up. I repeatedly told you, we don't want you to be arrested. We are not trying to arrest you. We just want you to leave. That was one instance. In January of that year, that same year, 2018, I got a call from Corinne that you were refusing to leave I don't think you were physically in her office, but right outside demanding records, demanding to meet with me. So I left my private office and walked over, and I had a conversation with you. You didn't like what I was telling you, apparently. I had to get, the police chief happened to be coming in. I brought Tom Owens up, and I believe another officer came. And again, nobody wants to physically arrest you. They just want you to leave when your business is over. And until police get very close to physically removing you, you don't leave. It's been my experience.
And who would you say makes the determination that my business was over? I noticed in those previous instances, you don't mention that you thought I was creating a disturbance.
You certainly were creating a disturbance in the Nets office. I had advised you of the city's response. You refused to accept that, and you refused to leave. And the same with that incident in January, when Corinne called over. You were not. I provided you an answer. You didn't accept it, and I told you there was nothing else that could be done, and you refused to leave.
And the city would insist that I was disorderly. Any instance where where you're referencing me as refusing to leave, I presume the city would maintain that I was disorderly in all these instances, and that's why I was asked to leave.
I don't know if you mean disorderly in the exact legal sense, but you were interrupting Corinne's ability to do her job and the Net's ability to do her job, and I had provided you the answer. You apparently didn't like it and refused to leave. You cussed me out. You cussed out the police chief. This is the January incident, and those are my experiences. And I had read again police reports of you creating disturbances at council meetings and with the prior city attorney.
Your Honor, I'm not charged with disorderly conduct, because it seems like that's the case.
This is your opportunity to question.
So, all right, so, can you say, in the January instance, you made the determination that I needed to leave?
I had advised you of the answer. There was nothing else that the city could do for you that day regarding the issue with which you came to City Hall.
All right, so under your impression, because I didn't have any more official business according to your opinion, then I was essentially without official business to be in the building, and I now refuse to leave.
Correct. The City Hall is obviously a public building, but where you were at were the offices of employees, and Corinne had to call me to come over to get you to leave because she had attempted, I think, to answer your question or your records request. Obviously, you weren't happy with that, so I was uncomfortable that an older woman was by herself with you, not you unhappy with her, so I went over there to address the situation, and I gave you the answer. You didn't like it. And again, you cussed me out, you cussed out the police chief from my recollection.
So nobody, the mayor, no executive officer of the city told you, the department head, to tell me to leave. You came up with this on your own.
That was what you're saying.
I'm asking if he was directed by someone from the city to tell me to leave, or if he...
What day are you?
Hold on, there's an objection. Overrule the objection. I overruled his objection. You can ask your question.
What day are you referencing?
Well, specifically on this day, he says that he told Assistant Chief Smith that he needs to leave, according to supplement narrative number 2, written by Chief Smith. She was Assistant Chief Smith at the time, you were correct. But she says, I saw City Attorney Nick Otis in the chambers, and he also advised that Throgmorton was in Fitzgerald's office and said he needs to leave. He just testified that he basically... Ask
your question.
Okay, so did Mayor Prince tell you to tell me to leave specifically?
No, I advised Julie Smith because I had previously given you the answer to the issue that you had brought up at the Board of Works. My experience was that you harassed Kareem.
I just need a simple yes or no, Your Honor. Did Mayor Prince advise you to tell me to leave?
I did, based off of my position as city attorney. You were going into my office area as the city attorney. It was my decision to advise Julie Smith that you needed to leave that office area.
I was told to leave the building. I'm under the impression that I am charged for refusing to leave the building and not his office.
I specifically said that he needed to leave. That was, I believe, what I said.
Okay, and do you believe that Chief Smith thought that I needed to leave the building because that's the message that she passed along?
I don't know what Julie Smith believed. I just know what I told Julie Smith.
Okay, what was your intentions on Julie Smith doing when you told her that I needed to leave?
That hopefully she would get you to leave the building.
Okay, so you told Julie Smith that I need to leave the building.
Yes. I said you need to leave. I don't know if I said, I don't believe I added.
But she knew what you meant in your opinion? Did you need to tell her the second time?
I believe I told her one time.
Okay, and off she went upstairs, and the next thing you know, we kicked out of the building?
I don't know what happened because I was not up there.
Okay. And basically you felt that I didn't need to be in the building because you anticipated that I could maybe, what did he say? Hold on one second, you're wrong. I believe you said you were concerned that I may try to intimidate or harass her.
Yes, that, and you specifically stated at the Board of Works meeting, if you don't give me the documents, I'm going to go get them myself. So I was concerned that you were going to physically enter Green's office in an attempt to take them without her consent. And frankly, I don't think that the documents were actually in her office anyway. I possessed them. And so did the court at the time that had them from an in-camera review that was produced.
So you were concerned that because I said I would get these documents myself, there was some sort of a threat or potential
Yes.
liability, property damage or something of this nature? Okay. And would that apply to the other instances where you have told me to leave? Did you feel, have I always said that I'm going to go into this office and get these documents and tell me to leave? Are there...
Usually the reason, there was, that day, the reason, my concern was I previously had a conversation with you on Friday before, so 3-4 days before.
Okay.
Had provided you with a response from the city that I needed an opportunity to speak with the city to make a determination about what they were going to do in response to the court order. You showed up at the Board of Works meeting. You said you had this, you interrupted the mayor. The mayor told you public comment was over. You continued to talk. You advised that the city doesn't give you the documents. You're going to physically go get them. There's some other conversation. The next thing I knew, you were upstairs at the entrance to Kareem's door, which is where you frequently interact with her. That's when I advised the Assistant Chief, Julie Smith, you needed to leave. That was my concern.
And are you aware that I previously filed a complaint with the city against Chief Smith?
No, really? No.
I believe that she has a bit of a bias. I've named her in a complaint, and the only 2 instances...
Perhaps she'll be called as a witness and you can question her, but that would not be for this
I'm
witness.
asking if the city attorney is aware of...
And he said no. Let's move on.
Okay, so you're not aware that there's a previous complaint. So are you aware that I was made to sign a confidentiality agreement in regards to this complaint?
I know that you had the previous city attorney, from responding to your records requests and reviewing records, there was some sort of confidentiality agreement. I don't recall what it was about because I wasn't present for it.
Okay. And based upon your responses in my public records requests, to your knowledge, this complaint was never investigated or no result. There's no findings from a hearing or any sort of board or anything. My complaint pretty much, there's no results that you can find in the city's possession.
Objection, relevance, and compound question.
I believe that the city buried my complaint, Your Honor, and I believe that every time I try to dig up records to prove that my complaint was never handled properly, somehow there's a law enforcement officer there to force me to leave. And there's a long history of it.
I can answer
Hold
that
on.
question.
Hold on. No, there's an objection. It won't be answered until I allow the question. I'll sustain your objection. It is a compound question. If you'd like to ask one question at a time, you may.
Is there a way that I can have her read me back my question that I just asked?
There is not.
Wrong, and I can. Okay.
There is not.
To your knowledge as the city attorney, is there any known complaint that has been heard and investigated by the city which I have filed? Beginning to end, been completed.
You recently filed a complaint against me with the ethics officer that I had a conflict of interest, and this is within the last 3 months. And she investigated it and issued an opinion that I did not have a conflict of interest with it.
Okay, and aside from that, that's the only complaint that you as the city attorney representing the city in pending legal matters, various litigation, you have no knowledge of this matter being completed by the city.
You complain about a lot of things, so
No, I mean an actual citizen complaint filed by the city on...
I'm answering your questions, Charles. You complain frequently about officers, department heads.
I would object, Your Honor. I'm not asking how often I complain or moan or just in generally unhappy with life. I'm asking about a specific citizen complaint filed on 8/20/2015 with the city of Newport.
Well, you didn't ask that. You didn't ask that question.
Before.
You didn't ask that question.
Okay, so is there a citizen complaint that has been investigated and determined that I'm lying to the city? You know, or that nothing, I filed essentially a public accommodation complaint. So are you aware of any resulting determination from my public accommodation complaint in 2015?
No, I'm not.
And to the best of your knowledge, would you say there's any paper trail past the confidentiality agreement for this complaint?
As I sit here, I don't know much about your complaint. It was in 2015. That's over 2 years before I became the city attorney, so I am not generally familiar with exactly what happened to your complaint.
Right. Do you have any recollection of any of my numerous public records requests where I've requested documentation on this complaint, providing anything meaningful that you as the city attorney would have, I don't know, noticed?
I don't know exactly what you mean by meaningful. I produced
Will
lots
you
of
review all these documents before you provide us with
Gentlemen, one at a time.
Sorry.
What's your question?
Do you review every document that comes to me, or is denied to me in my public records request?
I would say since I've been the city attorney, yes, I do review documents before they are produced to you in response to public records.
Okay. And do you recall producing any documents that show the end result of this so-called investigation that was forwarded to the prosecutor's office?
I recall producing that confidentiality agreement. I thought I produced other documents, but again, I said I don't recall that specific incident. And I understand what you're saying. Did I look at documents? I recall that confidentiality agreement. We produced hundreds, if not thousands, of pages of documents. I don't remember each page that we did.
Are you the principal or the agent within this relationship with the city of Newport?
I'm the city.
Legal conclusion.
I'm asking him his opinion on what he thinks his responsibility is for the city of Newport.
Sustain your objection. Would be a legal conclusion.
Have you ever been directed to tell me to leave the building by the mayor or any member of the city council?
I think you're getting into attorney-client privilege information. You're asking me what my client told me directly. I think that's attorney-client privilege. Unless the judge directs me to answer that, I'm not going to get into that.
I think it's a valid question. I think it should be answered.
I just want to be clear. Are you advising me to breach attorney-client privilege and answer that question?
I don't believe that would be attorney-client privilege, the information he's asked for.
To my knowledge, I don't specifically recall the mayor asking me to tell somebody to have to leave the building. My experience...
Enough said. Thank you. I don't want to cloud the issue. Enough said on that question. Answering.
Okay. And that would imply to anyone that has the authority to direct him as the city attorney to order me, not just the mayor. I understand that there's a an executive, legislative record, I'm saying, has his, I mean, I understand it's attorney-client relationship, but it seems to be an integral element of the offense, is that he was directed by the principal of the property to carry out he doesn't have the authority to decide this on his own.
Seems to be well settled in your closing argument, if you care to make one.
If I may, Your Honor, ask a point of clarity, or I guess, I'm not sure what the correct terminology would be, but I'm told the docket speaks for itself for everything else. Is there a way that I can get the actual trespassing charge? There's several different ways that one can be charged with trespassing. And according to the docket, I'm charged with trespassing on abandoned property, 7A and B. Property determined to be abandoned or vacant. And I just wanted to know, there's a difference between refusing to leave and being on a trespass list, which I'm, to the understanding, that's why I was arrested. It's because my name's on a special list. So what is the actual Indiana code that I'm charged with? Is it 7AB?
Did you get the discovery?
Yes.
There it is.
There's different IC codes on all sorts of paperwork.
I have no information other than what's in the discovery that you've been provided.
He has the information.
Okay, so on the docket, I'm charged with 7A and B. Is the city of LaPorte abandoned or vacant property?
Mr. Carter, I think that the clerk's office misentered what you're referencing, because I saw that as well.
I would object to that, Your Honor. He's going to need to prove that the clerk's office made a mistake on the docket.
I'm answering your question.
Well, I think he can answer it.
I don't want his opinion.
Well, I think he can answer it.
Affidavit, what you're referencing is not the basis for your trespass. As I understand it, the basis for your trespass is that Julie Smith multiple times advised you needed to leave. And I wasn't present when that happened. I'm assuming you refused to leave, and that's why we're here. The trespass list, as far as I'm aware, that you had previously been placed on, was not the basis for your arrest. And City Hall is obviously not the thing.
Okay, so did he just say that the probable cause affidavit is not the basis for my arrest?
You heard his answer.
Okay.
No, that's not what I said. I said the trespass list was not the basis.
Before, he said both of those statements. So,
Your Honor,
he was very nervous about saying it because it wasn't the best statement. But he just said that the probable cause affidavit is not the basis of my charge I'm here for today, and neither is the trespass list that I'm offering. So,
No, that's
Counsel, you wanted to be heard.
yes, Your Honor. I guess my issue at this point is this record is going to be horrendous, and it's probably terrible for the court reporter, Mr. Throgmorton, not asking questions, but constantly trying to argue with the witness and trying to ask questions to the court, who is not a witness. So I guess I would just ask that he be directed to ask questions to the witness so we can keep this moving along and so the court reporter can make a good record.
I would agree. I think most of your comments are better left for a closing argument when they're comments. You may question this witness if you have any further questions.
I'm not exactly sure why I was told to leave, Your Honor, and I'm not exactly sure.
Now is not the time.
Who
Do you have any other questions of this witness?
was it for me to be told to leave?
Again, I wasn't present, physically present when you were arrested, but your conduct during the end of the Board of Works meeting, you're immediately going to Kareem's office. I advised Assistant Chief Julie Smith that you needed to leave.
So you advised the chief that I need to leave?
Yes.
Were you advised to advise the chief?
No, I was not advised. I advised the Chief.
Okay. Your Honor, I would move for this to be dismissed immediately. He's not shown a manifestation of consent. He's a department head for the city legal department. He doesn't have the authority to ban me from the whole building. There's numerous cases where this has been outlined. This isn't going to cut it. He doesn't have half the elements of the offense. He doesn't have the authority to tell me to leave the building as an agent of the principal.
Your motion is
executive officer.
Your motion is premature. Perhaps wait till the state concludes its evidence.
The officer doesn't have the authority to tell me to leave.
Your motion is premature. Perhaps you should wait till the state concludes its evidence.
Okay, Your Honor, I would like to make part of the record for point of appeal. I'd like this dismissed now because he doesn't have the authority to tell me to leave, and I can't refuse to leave an unlawful directive.
Denied at this time.
Okay, thank you.
Do you have other questions?
So am I correct to believe that you think that I'm being disorderly, not disorderly enough to charge me with a crime, but disorderly enough to tell me to leave? So I was told to leave by you, and you were not given any. Let me rephrase this now. So you haven't been given any authority to tell me to leave by any executive officer of the city, and you are a department head, correct?
You were in the city attorney's office area. I directed the chief, the assistant chief, based off of your conduct, that there was nothing, that legitimate business that you had at that point was occurring, and that it was going to be based off of my experiences with you. You were going to possibly cuss at her, belittle her. You had told her all kinds of terrible things over the years. There was nothing that you needed to do there with her that day. You needed to leave.
So based upon my conduct, you determined that I have no official business there.
Not with Corinne and not in my office. I had already answered your questions.
Okay. But you weren't. You didn't actually see me interacting with Corinne. You anticipated that my interactions would essentially be considered a disturbance or disorderly, and you told me to leave, or you told the chief of Smith to have me leave. Which, Your Honor, I would maintain that the actual disturbance came from.
Why do you keep asking me? This is your time to question.
So you were the only person in the building that day that told anyone that they had the authority to tell me to leave the building.
I believe I do have authority, but also I believe, again, from watching the video that we posted on YouTube, Julie Smith multiple times told you that you needed to leave. Corinne told you there was, I don't know if she used the exact words, but there was nothing she could do for you. So I believe Julie Smith told you to leave multiple times.
1 second, Your Honor. Apologize. Got a lot here for all three. Okay, Mr. Otis, are you aware that a police officer who is neither an owner of the property or an agent of an owner of a property cannot create a trespass violation by asking the patron to leave and then arrest the patron when he refuses to do so?
I'm going to object to the relevance and legal conclusion.
Are you aware that the police...
Will you allow me to rule on the objection?
I'm sorry?
Or will you allow me to rule on the objection?
Sorry.
It is a legal conclusion, and I'll sustain your objection.
Mr. Otis, can you tell me where Chief Smith has the authority to tell me to leave? Because
I had told her you needed to leave,
okay, so you gave her
and I believe Corinne had told her that there was nothing she could do for you that day, and based off of that, I believe Julie instructed you to leave.
Okay, you say that you felt that you were reasonable in anticipating that I may create a disturbance. And you mentioned that based upon prior documents and reports, there is some stuff from the former city attorney.
Yes.
Okay. And do you believe that you have all the information in regards to that documentation?
I don't understand what you mean.
Well, you mentioned that you were aware that a complaint happened, but you were unable to find what the results were. So basically,
I did not say that. I said we produced a lot. I don't know the results.
I mean, based upon your public records denials, you told me that nothing else exists in regards to my...
Objection, that's not a question.
Okay. So... do you feel that the city attorney has provided you all relevant public records to my complaint when she left office? Or do you think that it's possible that you don't have all public records that should have left with you?
You're asking me to speculate what the prior city attorney provided. I don't know what she provided you or didn't provide you.
Okay, you say I was not arrested for trespassing because I'm on the trespass list.
That's my understanding, was that because I had previously told you that you could, at some point when I became the city attorney, you could come to City Hall as long as you conducted legitimate business, which is the standard for everybody. If anybody comes in and starts cussing out our employees, making a scene, well, they're going to be asked to leave. You, for some reason, almost every instance, create a situation that is hostile, difficult, and raises the tension of everybody in the room.
Are any of these things illegal to knowledge?
Objection, legal conclusion. I don't know.
Sustain.
Tell me I was trespassing because he feels that I was disorderly. I'm just trying to...
I sustain the objection.
I don't understand why you're here today, Brian, because I'm not charged with disorderly conduct. He seems to be testifying that I was disorderly, so I was told to leave.
Mr. Throgmorton, would you have any more questions of this witness?
Other than your emotional concerns, is there any other justification that you believe exists for telling me to leave the building? Other than your opinions, is there any factual information that exists that justifies me being removed from the building?
Yes, based off of your prior conduct.
Right, prior conduct that you're claiming.
Hold on. You asked me the factual basis.
Okay.
Your criminal history, including bringing a loaded gun to a school, but after you were...
I object to the relevance of this, Your Honor.
I'll sustain that objection and strike that from the record as well.
He asked me the facts, providing the facts. I'm concerned based off of your criminal history and your conduct at City Hall, particularly with women. Your behavior towards women.
I would object to all of this.
Well, you asked the question, so overrule the objection. You asked that question.
You displayed knives to the former city attorney, put knives on a table when she was pregnant. I don't see any...
I would object to that. There's no factual basis for this. It's in the confidentiality agreement. He doesn't have the records that prove that happened.
Maybe you shouldn't ask the question. Overrule the objection.
Where did you get that information?
Multiple employees, the police have told me that. I think Becca has told me that. I thought I read it somewhere, but if I'm wrong, maybe I did read it somewhere. But it's been reported to me by multiple people. You displayed knives at the police department one time, according to police officers. You make veiled threats that I think, again...
Did you say that...
I'm answering your question, Mr. Throgmorton. You continually make veiled threats that when you ask about why aren't you charged, I think they walk in front.
I would object to him testifying to all this hearsay, Your Honor. It seems to be a bunch of hearsay that he has no personal knowledge of.
Then why did you ask the question?
I'm simply asking what legal basis he has. It seems to be all of his opinion.
Well, it's a pretty broad question you asked.
Okay. So other than your emotional...
Well, I'm still answering the question, Mr. Throgmorton. You displayed knives to the pregnant city attorney.
Object to hearsay.
Again,
Overrule.
you asked me what I understood. These are what people report to me. You've cussed me out multiple times. You've cussed out police officers. You make women feel uncomfortable. Your conduct towards county employees has been deplorable. Every interaction, if somebody doesn't give you the answer that you want, you create a very hostile, intense situation. And I'm not, because of the judge's prior ruling, getting into your specific former criminal conduct, but based off of that, it is concerning. We are concerned that you may show up with a gun and action may have to be taken to stop it. We've had a mayor killed by somebody with in this community. Our mayor and his wife were killed by somebody that had some sort of mental condition. You repeatedly show up at City Hall and say you have various mental conditions, and maybe you do, and I'm sorry that you struggle with that, but it nonetheless puts everybody feels concerned.
Other than the concerns, the general lack of health care, underdiagnosis for various other mentally ill people throughout the community, do you have any reasonable suspicions that I'm going to shoot up City Hall or bring a gun or whatever, based upon, I mean, Your Honor, I've been out of trouble for a year. I would object to all of this. This is his personal feelings based on. You mentioned that people have told you this, so can you elaborate what people told you? Can you specifically answer?
Gentlemen, let me interrupt.
What person told you?
Let me interrupt, Mr. Throgmorton. When I speak, nobody speaks. Period. End of discussion.
I apologize.
Line of questioning is of no benefit to the court to the issues at hand. We'll move on and limit ourselves to the specific instances, in this case, June 5th, 2018, for further questioning.
Your Honor, this seems to be pretty much about my personality and whether various public officials like me. And I don't really feel like I'm going to be allowed to present the facts that actually matter, so I don't know if I have much else to say.
Okay. No further questions of this witness?
Based, honestly, Your Honor,
No further questions of this witness? Thank you. You may not.
Actually plead guilty.
You want to plead guilty?
Or I may want to change my plea, and if I would be allowed in a couple seconds here to voice myself.
Well, hold on a second. Hold on a second. Did you just say you wanted to plead guilty to the charges?
I said I may want to plead guilty. I may have. Your Honor, I don't want to waste this court's time as much as that may be everyone's belief here. And to be perfectly honest, I would love to argue this out based upon the First Amendment principles and stuff like that, but the bottom line is, I don't want to offend this court. If my arguments aren't going to be heard, I would like to go home to my family. I'm currently a stay-at-home dad. I have a 10-year-old who's currently upset because I can't make his spelling bee this morning.
I am here to hear this case and limit this case. And I'm happy to hear this case. It is my sworn duty. But I'm not here to talk you into something, Mr. Throgmorton, or talk you out of pleading guilty. And there are a number of cases to address. You are a grown man, you can make your own decisions. And before you...
I'd like to plead no contest on all counts, Your Honor.
Don't have that in Indiana on misdemeanor charges, only on tickets and infractions.
My options are guilty and not guilty.
Yes, sir.
I would like to plead guilty, Your Honor. I don't want to waste this court's time. I don't necessarily feel comfortable with the back-to-back trials. I've done my best to try to prepare for this, but my resources are very limited, which is no fault of anybody's but myself. But, I would rather pray for the mercy of the court. I'm going to have to plead guilty on everything because...
You don't have to do anything. This is still America.
Based upon... I would love to see a ruling that took, the various, First Amendment protected activity claims and self-defense and all that into account. But to be perfectly honest, Your Honor, I don't want to risk offending this courtroom. And
And I don't feel comfortable enough to present my case in the fact that I don't feel, like I'm going to be able to do this at this point. I wasn't prepared for it to go in this order today.
That is exactly why I cautioned you as to the perils of self-representation.
And, I might have misanticipated how the COVID stuff is going to, I reasonably anticipated I would be able to have somebody here present with me, like another human simply for moral support even. I didn't know that nobody was going to be allowed for the trial until the other day, basically.
My understanding, that is the county commissioner's directive during the pandemic.
I talked to a county commissioner, and he couldn't provide me any information with it. I tried to figure all this out, but...
So, I'd rather get back to the issue at hand.
At this point, Your Honor, all of this time has went by. I'm going to have to plead guilty and pray to court. I don't make this decision lightly, Your Honor. This is the current situation in the jail. There's a surge of COVID-19.
I can't see that far, so.
I apologize, Your Honor. It's the weekend edition of the local report, County Herald Argus, that reflects it.
Well, let's get down to some business then, gentlemen, and let's excuse the witness for the moment.
Thank you, Your Honor.
Have you been subpoenaed to appear?
I believe I have.
We'll keep you under that subpoena for a few moments.
Yeah, you want me to stay out?
If you would stay out in the hallway.
Okay.
Thank you.
All right.
Well, let's reset a record, and I just want to be certain that everybody's doing what everybody wants to do, and we're going to limit ourselves to case number 1721 for the moment. Now, it's my understanding, Mr. Throgmorton, that you now intend to withdraw your not guilty pleas and plead guilty to the 2 charges.
You said to the 2 charges.
There's a resisting law enforcement charge and a criminal trespass.
Yes, sir. Actually, Your Honor, if I may clarify really quick. Based upon these 3 charges being together, how do they affect each other before I handle anything officially?
Well, there are only 2 charges in this
that all this time, basically, it's going to run consecutively.
If you were to plead guilty on more than one case, and that is a big if, sentencing has to run consecutive.
Okay.
Can't run at the same time.
17 and 21 and 1755, there's no, I'm there at the same court order on both instances. That's not a crime spree or something?
It is not.
It's worth it.
No. Now, I will tell you, though, that it's option to the court that the 2 charges in this case could run concurrent if you plead guilty to 2 charges at the same time. But each individual case has to run consecutive.
Why not, Your Honor? Yes.
Well, it's really Chris. I shouldn't call you Chris. I'm sorry. Mr. Throgmorton. This isn't a why not situation. This is serious business. It's no joke.
I understand that, Your Honor. And if I may address, I was going to go to this trial today because if I could win these, I'm essentially eligible for an expungement. And for the past few years, I've been trying to, I have a criminal history, but I've been trying to essentially deal with that. I don't want to make excuses for my criminal history,
Sure.
but I understand that it's an obstacle that I have to deal with. I'm a lot more things other than concerned with police, accountability, and transparency in government. I'm a nature enthusiast, a lot of other things.
So, let's get back to the issue at hand. Did you want to plead guilty, or would you prefer to maintain your not guilty plea? By the way, and I'm trying very hard to make a clear record, you are presumed to be innocent of these charges. It is the state's burden that has to prove you are
I
guilty.
don't feel presumed to be innocent.
Well,
and it's nothing personal to based on,
so tell me what you want to do.
you're judge number 8. I went through multiple unbiased judges it just, I don't want this to proceed to the point where I have offended this court or feel that it's necessary. Like, I would like to go home today. I would like to be a father.
I can't tell you what will happen if you're
I know you're
convicted.
not, and you can't, and that's why I feel like I have to create as little frustration and time wasted as possible for everybody involved here. I apologize that we're all here today.
You should not.
But with the cumulative, what I believe to be prejudicial effect, are
from the beginning, back to back to back. I'm concerned that.
So what do you want to do?
I'm concerned I may get a little excited and get myself in more trouble than I'm already in, Your Honor.
What do you want to do?
I'm trying to be an outspoken advocate for the issues that I believe are bigger than myself. But if I'm
Mr. Throgmorton, what would you like to do?
about myself, I got to be guilty to
All right.
this because I'm not really.
All right. Well, before I accept your guilty plea,
Or to let me get my affairs in order, I suppose.
let me,
This will happen.
I'm sorry? I just didn't hear what you said.
I would just ask to address it before any sort of sentencing or anything. I would ask that the court allow me to address.
Oh, of course. I'll hear from both comments, both sides, before I impose any sentence.
Services and situations when I have some mental health issues for a reason. But I would like to be able to bounce back from this and lead a productive life.
All right. Well, Mr. Throgmorton, raise your right hand and I'll place you under oath, sir. Do you swear or affirm the testimony you're about to give will be the truth?
I do, Your Honor.
You put your hand down. And will you state your name?
My name is Christopher Adam Throgmorton.
What is your address?
I live at 1607 J Street.
Is that in LaPorte?
That is in LaPorte, Indiana.
And the zip code there?
46350.
Well, sir, what is your birthday?
May 13th of 1985.
And what are the last four digits of your social security number?
6381.
Oh, before I accept your guilty plea, let me again advise you of your rights. Now, as I mentioned, you are presumed to be innocent of the charges in this case. And to that end, you are entitled to be represented by an attorney, and that would include having an attorney assigned to represent you at little or no cost if you are indigent. You have the right to a speedy and a public trial by a jury. However, to have reserved your right to a jury trial in this case, you would have had to make a written demand for such at least 10 days before your first scheduled trial date. You do have the right to confront, question, and to cross-examine every witness that may testify against you. You have the right to subpoena witnesses. That is required. Witnesses appear in court and testify for you. You have the right to require the state prove you are guilty beyond a reasonable doubt before you can be convicted. You have the right to remain silent. And you have the right to appeal a conviction if you had a trial and were found guilty. Do you understand your rights?
I do, Your Honor.
By pleading guilty, sir, you are waiving and giving up your rights. Do you understand?
Once I have left, I wait.
Well, the rights I advised you of. Do you understand you're waiving those rights?
Yeah, the ones that haven't been waived for me, I waive.
Do you understand by pleading guilty, you'll be judged guilty and then sentenced without further trial?
Unfortunately, yes, I do.
And is this your own free and voluntary decision?
It's not all the other factors, Your Honor. I don't really feel like I have a choice. So yes, it is my choice.
Just asking, sir.
Yes.
Mm-hmm. Also, would you care to establish the factual basis to the charges, or would you prefer the court?
Are you okay with me asking you questions, Mr. Throgmorton, or would you rather the court do it?
We're here now. By all means.
Okay. On the 5th day of June 2018, were you at the LaPorte City Hall here in LaPorte County?
Yes.
Okay. And while there, did you knowingly or intentionally forcibly resist, obstruct, or interfere with a law enforcement officer while that officer was lawfully engaged in the execution of that officer's duties?
I don't believe that's the officer's duties, but I believe they're trying to arrest me for criminal trespass, so sure, yes.
Okay, well, let me flesh that out a little bit. Do you agree that you pulled your hands away from the officer while they were trying to arrest you for criminal trespass?
I'll not disagree.
Okay, so
Object anyway.
So you agree with that?
That's what I'm told the story is, so sure I agree.
Okay.
Facts are stipulated by better man, so yes.
Okay, well, on that same day, were you asked to leave the real property of LaPorte City Hall located at 801 Michigan Avenue in LaPorte, Indiana, and you refused to do so after being asked to leave?
I was told to leave by a threat of force, and then I absolutely refused.
And by threat of force, you mean the police were there and they asked you to leave?
Yes, I mean that there was armed policy enforcement officers that worked for the city of LaPorte, not the police officers there to use force against me if I did not leave.
Okay, and you resisted that force?
I didn't volunteer my hands, no.
And you did not have a contractual interest in the property of LaPorte City Hall. In other words, you didn't have an office there, you didn't have an apartment there, you didn't have a written document that said you had a greater interest than any general person in the public.
A greater interest than the general public?
Correct.
I'm not really sure that I understand what the general public's interest is, because I'm charged with trespassing.
Do you want to plead guilty or not?
But I guess, yes.
So that's yes, you did not have a contractual interest?
Oh, my bad. No, I did not have a contractual interest, other than whatever the general public's is, and I'm not special more than the general public.
I don't have any other questions, Your Honor. I would just offer the criminal information and affidavit of probable cause to supplement the prima facie case.
Any objection to that being admitted, Mr. Throgmorton?
No, Your Honor, that'd probably actually make them a public record for once. So.
We'll grant your motion. Anything else as the factual basis, counsel?
No, Your Honor.
All right. Well, we have established a factual basis for both resisting law enforcement, a Class A misdemeanor, criminal trespass, a Class A misdemeanor. Court will accept the defendant's guilty pleas. Consider the sentencing aspect of the case.
We're moving to sentencing, Your Honor?
Moving to sentencing.
Thank you. Well, Your Honor, I guess the first thing I would mention is the defendant's criminal history. He has two theft convictions from August 2003 out of Grant County. He has a dealing in marijuana case from 2013 out of, I believe this is LaPorte County. Yes, LaPorte County. He has a resisting law enforcement case from 2008. That one's out of Porter County. And then he has this gun case that's been alluded to that I believe started in Tippecanoe County but ended up in a federal case with a federal gun conviction. That appears to be around 2004 based on the records that I have. My concerns with Mr. Throgmorton, if this court were to give him any type of suspended sentence, and the court heard a little bit of the testimony on the first witness, is he has just this long history with everyone in local government here in this county and LaPorte City, I think, of just failure to comply. I think if he is placed just on a probationary sentence, he's just going to end up violating it, and he's going to probably cause more issues for himself. My recommendation for this case would be give him a 6-month executed sentence, whether that's executed in the county jail or whether that's executed in some sort of alternative community placement. I would leave up to the court, but I don't believe, based on his history and based on the fact that he just fails to comply with any kind of lawful demands made on him, he would be a good candidate for a suspended sentence.
Sir, you care to be heard?
Yes, sir, Your Honor. So I don't deny that I have a lengthy criminal history at all. I would point out that some of this is fairly older. Specifically, the marijuana charge actually extends from 2010. The felony ends up dismissed. I'm recharged with a lower charge in 2012. I actually pleaded guilty in 2013. But between 2010, that arrest, and the 2016 arrest that is dismissed as no probable cause, and all of these, I've tried my best to stay out of trouble, best I can. It wasn't really until I started getting concerned about local politics and my government that I started getting in trouble again, because I had no reason to really interact with police officers or anything. I was out of trouble for years, and that's incidentally why I ended up filing my complaint. Is I've been out of trouble for years, and a correctional officer from the jail recognized me, and I was concerned that it was going to happen again. I've done numerous things with my life outside of this. I tried to volunteer. The trajectory that my life is on, once I was done with these, I fully intended to commit to the rest of this stuff. Oh, well, I've taught at the Indiana Department of Environmental Management, taught children, for my local Fort County Solid Waste District. I led high school students on an Envirothon tour for the solid waste district in the county. I've participated extensively in various community stuff. I've tried to bounce back from my history quite a bit. And I understand it's there. As I said, I was going to go, if I won these trials, I was going to seek out an expungement. I'd like to go back to school, and I'd like to do something. I've had a lot of people tell me that I've wasted a lot of my potential on these fruitless endeavors. And that I fully agree with. I fully believe that I've wasted a lot of my potential on pursuing public record. I basically felt that I had been lied upon, and I wanted to prove that the city attorney was inaccurate and just kind of got out of control, to be perfectly honest. But when all this happened in 2018, my life was completely different. I was a completely different person then. I didn't get to see my child nearly as much as I wanted to. In the summer of 2019, I was awarded sole custody of my 10-year-old boy. A child who is just like his dad. And
I'm sorry, when?
August 20th of 2019, Your Honor. I was awarded sole custody of my 10-year-old boy. His mom is the way my mom was. She's a drug addict, and she doesn't care about him at all, and he's going to be raised by the system without a father around, the same way that I was. And I don't acknowledge I've made a lot of mistakes here, and I'm a bit brash and loud and vehement and caustic. But none of these things are a crime. I mean, I don't deny that a lot of people dislike me. But jail is, I don't think I'll do any time that was given to me today, because I have to. I don't have a choice, obviously. But I'm concerned that I won't be a better person afterwards. For instance, I have a diagnosis of post-traumatic stress disorder. My mom was brutal as a kid. I've had this for 15 years, roughly, diagnosed. I have sensory issues, diagnosed. I have court-ordered psychedelics that back up, solitary confinement for the jail policy right now, because of the 48 testing positive and 95 in quarantine. Is I go to jail, I'm doing 14 days essentially in quarantine, solitary confinement, immediately. That's going to do irreparable damage to my mental health. I won't make it out of jail after 6 months. Not the me that has potential and hope still. I would ask this court, allow me to do what I want to do anyway, and I will do as much community service as you can legally give me. Because that's pretty much what I'd rather be doing with my time anyway, is right now, I can't donate my time. Like, there's programs that I've tried, I used to be able to do a lot more, but intimidation is a very accurate accusation. So is battery. So, volunteering at the library, a lot of this stuff is just dead now. I won't be able to voluntarily do community service anymore. So I'll take thousands of hours of community service. And as far as probation goes, to be perfectly honest, I was absolutely raised by the system. I was not raised in anything but the school-to-prison pipeline. I've had structure my entire life. I think I'd honestly stay out of trouble easier on probation because there's an incentive. I don't know how else to explain it, but Uncle Sam is my actual father. I was raised by the justice system. And that seems to me why I've taken what I deem to be a lack of respect for it so personally. But I would ask this court, consider, the punishment versus whatever contribution I can make. I don't feel like I'm going to learn any lesson in the jail. I'll probably be taught numerous other ways to commit crimes that I don't really care to know by everybody in there. But if this court would hold me accountable, if this court seeks to hold me accountable for my behavior, I would request that my punishment be to do something restorative within the community that I'm alleged to have harmed. But, I don't even think the jail wants me in there, based upon who I am. And not every public official hates me as well, Your Honor. Like, Sheriff Boyd actually and me have a pretty good rapport. I'm trying to figure out how to get his inmates involved in community gardens. And he would love to see me be able to put my efforts towards that as well instead of this. I've had the prosecutor that resigned or recused from this, Mary Lake, before she's the chief of staff. I literally put her as a job application reference for the Insight Garden program that was basically introducing juvenile inmates at the Locust Court Juvenile Facility to garden as a trauma therapy for essentially post-incarceration centers. But I don't have any problem taking whatever punishment this court gives me, Your Honor. I would just ask that it achieve some sort of a purpose. Simply putting me in the jail, which, we haven't rehabilitated anybody since the 70s. These are merely warehouses for people now. I'm not going to better myself in the county jail or any facility at all. And I don't want to be a dependent on the state. I would like to contribute to society. I fully agree that me running around being a government watchdog hell-bent on transparency, maybe that's not the best way I contribute to society, and I'm fully ready to accept that. But my potential dies during a jail sentence, Your Honor. I've done a lot of time. It has its effects on my emotional and psychological abilities to interact with the society that I live in.
Let me ask you a question or two. Do you work?
Up until March of last year, Your Honor, I worked at Pine Lake Marina for about 5 years, installing boat lifts, docks.
And what do you do now?
I used to install his boat lift.
What do you do now?
I'm currently stay-at-home dad now.
And how do you get by? Get bills paid and what have you?
Okay, so
short answer.
My significant other, essentially, we did some calculations. She makes a little bit better money than me. I'm off for the winter time, so we just had a baby March 17th of last year, the day that this state of emergency was declared. And based on all this COVID stuff, my 10-year-old that I have custody of was doing a lot of e-learning and whatnot, so we basically made the decision that I would...
You're the stay-at-home father, and
right now,
your significant other handles the finances? Is that?
Yeah, I clean, I do the laundry, I do the cooking, I feed the dogs, I shovel the driveway, all the domestic responsibilities, keep the kids alive, etc.
And are you currently on probation for any case anywhere right now?
No, Your Honor.
Are you currently under indictment information for any other charges anywhere else?
Other than the 3 that are in front of
Only the 3 here?
Not that I'm aware of.
All right. Well, let's take a short recess and come back in and I'll pronounce the sentence. Maybe 10 minutes?
Am I allowed to go outside and get fresh air?
As far as I'm concerned, you can.
Oh, this is the first time I've done this bit. I didn't know what the procedure was.
So we'll see you back here. We'll call it 10 minutes.
All right, please rise.
Thanks, folks. You can have seats for me. Good morning again. Back on the record, 46 DO3 1807 CM 1721. Parties appear, state represented by Special Deputy Prosecuting Attorney, defendant appears pro se. Court having previously accepted the defendant's guilty pleas to the charges of resisting law enforcement, a Class A misdemeanor, and criminal trespass, a Class A misdemeanor. When I'll sentence the defendant as follows, and then we'll comment. Let me recite my entire sentence before you ask me any questions about it. The court on count 1, that is resisting law enforcement, sentenced the defendant to 180 days in the LaPorte County Jail, suspend all time but any time served, which I don't believe is any on this case. At least the record doesn't reflect. Will impose a $15 fine, court costs of $185, place the defendant on probation, a general order of probation for 180 days. Court will accept the defendant's guilty plea to count 2, criminal trespass, sentence the defendant to 180 days in the LaPorte County Jail, suspend all but any time that may have been served, whether it's 0, whether it's 10, it's still suspended. Place the defendant on probation for 180 days, that is per general order, and we'll waive the fines and the court costs on the second count. Court will order the sentences to run concurrent. Comments, and then I'll listen, Mr. Throgmorton, any questions. I think the prosecuting attorney and what I've heard today have some legitimate concerns with regards to your conduct in the past. I will tell you that your appearance before me on these limited occasions has been nothing but stellar, zealous, but nothing but stellar. I believe the sentence to be an appropriate sentence in this case.
Thank you, Your Honor.
What did you want to say? And we're limited to this case right now. I understand we have 2 more to address.
I think he has a day or 2 credit.
He may have. I'm just going by what the docket shows.
Right.
I'm not, so I don't anticipate that.
Well, you're not serving any more jail time on this case.
So I'll.
Now, you will have to call probation, schedule an appointment to get signed up for that probation.
All right.
Now, your rules of probation will be incorporated by references that you will sign. You'll have to live by those rules for the next 180 days, and I will caution you for whatever it's worth. I would greatly prefer not to have to revisit this case.
Will not.
Judge, if I may,
You may.
may the fines and costs be paid during his term of probation?
They may. You may pay those during your term of probation.
Okay.
And we may address those later. We have 2 other cases that we need to address. I believe at least one of those has a bond of $600. And depending upon how that case turns out, we may revisit the fines and payment of fines and court costs here.
Your Honor, if I may, I would love $300, $600, and I could totally use it, but the court has already returned that bond money to me. So when I was arrested on the criminal trespass in June, I came for a hearing that Charles Watterson's.
Well, I don't need those
They gave
details.
my bond money back already.
They gave you, well, I'll be darned.
Yeah,
I don't think I've heard of that before.
I would love the free $600, but I don't, yeah.
And that will be the sentence on this case. And that is my sentence.
Thank you.
All right. Shall we move on then to a second cause number?
By all means.
Are you going to plead guilty to it, or are we going to do the trial?
No, we'll plead guilty to everything today.
Okay.
Shall we address 1807 CM 1737? That would be the battery charge.
I'll waive any formal readings. I know what I'm charged with. We can skip right to the end if anybody.
Well, hopefully, before I got involved in this case, all those steps had been taken. And Mr. Throgmorton, raise your right hand, and I will place you under oath. Do you swear or put your hand down first? Let me set the record. Madam Reporter, I apologize. This is 46 D03 1807 CM 1737, State of Indiana versus Christopher Throgmorton. Parties appear for bench trial. My understanding, defendant intends to withdraw a not guilty plea and enter a plea of guilty. Is that correct, sir?
If it hasn't been dismissed as self-defense already, Your Honor, I presume it's not going to be, so guilty, yes.
Raise your right hand now, and I'll place you under oath. Do you swear or affirm the testimony you're about to give will be the truth?
Yes, sir, Your Honor.
Put your hand down. Will you state your name?
Christopher Adam Throgmorton.
Sir, what is your address?
I live at 1607 Bay Street.
And that's in LaPorte?
That is in LaPorte, Indiana.
And the zip code in LaPorte?
46350.
What is your birthday?
May 13th of 1985.
And you are 35?
Yes.
What are the last four numbers of your social security number?
6381.
Sir, before I accept your guilty plea, let me advise you of your constitutional rights. You are presumed to be innocent of this charge. You do have the right to be represented by an attorney, which includes having an attorney assigned to represent you at little or no cost if you are indigent. You have the right to a speedy and a public trial by jury, although as a misdemeanor charge to preserve your right to a jury trial, you would have had to file a written demand for trial by jury at least 10 days before your first scheduled trial date. You have the right to question, confront, and to cross-examine every witness that may testify against you. You have the right to subpoena witnesses, require witnesses appear in court and testify for you. You have the right to require the state prove you are guilty beyond a reasonable doubt before you can be convicted. You have the right to remain silent, and you have the right to appeal a conviction if you had a trial and were found guilty. Do you understand your rights?
Do you, Your Honor?
By pleading guilty, you are waiving and giving up your rights. Do you understand?
I understand that, Your Honor.
And is that your intention today?
It is, Your Honor.
And counsel, would you care to establish the factual basis for us in this case?
Thank you, Your Honor. Mr. Throgmorton, on or about the 3rd day of July 2018, were you in the county of LaPorte, specifically in the city of LaPorte?
Yes.
Were you in front of the City Hall building in a crosswalk?
I was in a crosswalk.
Okay. Did you come into contact with a Mitchell Ficus?
Come in contact with?
Did you see him pass you by in the crosswalk?
Yes, we actually had a conversation.
Okay. You made a comment to him, and then Mr. Ficus made some comments back to you?
Yes, we had a verbal exchange.
Okay. And during that verbal exchange, did you strike Mr. Ficus in on the left eye or around the left eye with your cell phone?
After he grabbed my cell phone, yes.
So that's yes, you struck him in the left eye with a cell phone?
I struck the individual that had grabbed me, yes.
Okay. And you would agree with me that by hitting him in that left eye area with your phone, it resulted in the bodily injury, which we've alleged as redness and swelling in the left eye?
Yeah, it was like
I'm sorry, I didn't hear you, sir.
yes.
And you understand that by pleading guilty, you're waiving any claim you have to assert self-defense?
Yes.
Your Honor, I don't have any other questions, but I would offer the criminal information and affidavit of probable cause to help establish the prima facie case.
Have any objection if that's admitted?
I'm hearing mention of rude, violent, or rude, insolent, or angry manner, so I was just wondering if you're going to establish that for the record. If I'm going to plead guilty to this, I would like the accusations to be as clear as they are.
Well, I just assumed it was rude, but would you agree with me that hitting someone in the face with a cell phone is rude?
I'm told it is. I have a feeling that if I grab somebody else's phone and they hit me...
Let me stop you here, Mr. Throgmorton.
Yes.
I don't want to tell you to do, all right? Do what you want to do, but more often than not, a further explanation clouds the whole issue.
Right.
And I don't want, I'm not trying to talk you into it, I'm not trying to talk you out of it.
Yeah, I don't want to compromise these, so yes, it was rude, insolent, or angry in some way, shape, or form.
I don't have anything else, Your Honor.
All right. And then did you have any objection to the probable cause affidavit and the charging information being admitted, Mr. Throgmorton?
Is the video of the incident being admitted as well?
Only the charging information and the...
And if the affidavit mentions the video, that's not automatically a part of it?
It is not?
Okay. So, then the video does not become part of the record.
Does not? Your testimony is the major part of the record.
Okay. And the video is not part of the record now?
It is not?
Okay.
Really?
Yes.
I beg your pardon?
I don't have any objections. Yes, on all accounts.
Sorry, yes, you don't have an objection?
Yes, I apologize. No, I have
Okay.
no objections.
All right.
Yes to all these questions. As long as she factored this.
Anything else on the issue
As to factual basis?
as factual basis?
No, Your Honor.
All right. The court will accept the defendant's guilty plea to the misdemeanor of battery. We have a originally alleged victim, now a victim. Victim's entitled to make any statements at sentencing. Are we able to incur sentencing, sentence the defendant today, or care to waive? Or could victim care to make a statement?
I have a victim here, and I believe you would probably like to make a victim impact statement.
All right. Now would be an appropriate time for that.
Thank you.
A.
Hey, thank you. There isn't a B, is there?
There is, but this isn't.
Yeah, okay, because I thought I heard a B here, so I just want to make sure.
So you can actually have a seat right over there at the council table for me.
Because of your medical issue, you can leave your mask on if you need to. I'll move out of the way.
And as in the past, it would be your choice. Care to leave your masks on or remove them, try to maintain a social distance, whichever you are comfortable. Sir, what is your name?
Mitchell Ficus.
You are the victim in this case. This is case number 46 D03 1807 CM 1737. You are the victim in this case?
Yes.
Sir, we are at a sentencing aspect of this case. You are entitled under the law to make a sentencing or a victim statement. Now, it is not cross-examination. It's not a questioning. You won't be asked any questions. You don't have to clarify anything. You are allowed to make any statement that you care to make as I consider sentence.
Okay. Well, the only thing I'll say is that I was hit with this poem so hard that I started seeing stars and fell to the ground immediately. I was on my hands and knees, and I couldn't get up. I was bleeding profusely with a head wound. I still have a scar from that head wound right here. At the time, I had liver disease. 2 months after that, I had a liver transplant, and so I was actually sick at that time. I was very sick. So, I just they had to glue it back together instead of stitches. I didn't want stitches, so they just glued it, which was quite painful. So that's kind of what happened in my statement.
Does that conclude your statement then?
Yes.
All right. Thank you.
Is that it?
That's all you want to say? That's it. Your Honor, would the court accept photo documentation of the victim's injuries?
Do you want to admit those for sentencing purposes?
Yes, Your Honor.
I will.
Yeah.
You know what this was taken?
The day of. State's Exhibits 1 and 2, Your Honor, for sentencing purposes.
We'll have those marked. I assume our court reporter, you prefer numbers, or do you prefer?
Numbers.
All right. And now your argument as to sentencing, if you care to make one. Any recommendations, counsel?
Thank you, Your Honor. Would you like me to recite the criminal history again?
I do not require that or need it.
Okay. As stated at the other sentencing hearing, I guess I would note that he does have a criminal history. In this case, it's more than just disobeying lawful orders. It's him inflicting injury on the victim in this case. If you look at the probable cause affidavit filed with it, this started over a disagreement, I guess, about politics. I believe the defendant's going to try to minimize his conduct by saying that he tried to grab his phone, touch his phone, whatever, and that's why he hit the victim. I believe the use of force in this particular case is far beyond what is both subjectively and objectively reasonable. We live in a civilized society where we resolve our disputes here, like in court, and through political processes, not through violence in the street. And I think, based on the fact that he injured someone in this case, he deserves 6 months executed, be that in the county jail or through community corrections placement.
Mr. Throgmorton.
I would just reincorporate my previous statement to the court. I would like to point out that I'm not trying to argue that I didn't intentionally hit this man. However, the situation caught me a little bit off guard, and I reacted somewhat instantaneously, poorly as it may be. But I will say, as far as mitigating circumstances go, once this happened, my immediate priority was this gentleman. Like I'm known for recording. I'm very concerned just being in this building, not being able to record it or have it documented. This is literally what I'm known for throughout the town is recording public officials, just in case I have a reason to have documentation. I ended my recording and immediately called 911. I stayed away from him. Like, the video's not admitted, but that would show that I was more aggravated with myself immediately afterwards. I don't go around just walking up to people and punching them in the eye. I'm not exactly, I'm not dumb. I understand that's going to get me arrested. To be perfectly honest, yes, it was a conversation that got a little heated about politics, and I let my Republican values of thinking that I have the right to defend my personal property get the best of me. I fully acknowledge that we live in a civilized society. It's not okay to put your hands on somebody else, or to put your hands on somebody in response to them doing it to you. I don't acknowledge that my actions were wrong here. I'm very disappointed in myself. However, I would ask this court to recognize that I did have the foreseeable intentions of this situation arising. So when I responded, I wasn't on my best thinking. I had some impulse control there. I responded. But I will point out, I'm not trying to say that his eye didn't get injured. I didn't hit him more than once, and it was sort of like I didn't even actually hit him with my hand. My phone hits his eyeglasses, the best I can tell. But it was more of a knee-jerk reaction that's got me into a little bit of hot water here. So, and there's been a no contact order with Mitch Fikes. I fully honored that. I've had no instances where I went outside of this court's processes to try to, if anything, I've avoided contact with him. Like I said, I used to work at the marina. Mr. Fikes lives on the lake. He has a boat. Prior to this instance, we actually had some informal interactions where I would install his boat lift and his docks and whatnot. He was actually a pretty pleasant guy at the time I met him before that. Shook my hand and otherwise. This situation happened, and in my opinion, neither one of us handled it correctly. But I'm the one here taking responsibility for it. So I would, again, just ask this court to consider that I didn't just beat this man relentlessly. I had a reaction that I regret, and I immediately regretted it. I mean, as I said, if the video was in evidence, I immediately am concerned with myself, essentially, that this happened. Immediate remorse. Perfectly honest, I was confused, and I thought I had the right to stop what was happening with me, and I didn't handle it the best way, apparently, so here we are. But again, I would just reincorporate you know, jail isn't going to do me any good. I would seek out any restorative measures for the community as opposed to punitive whatever punishment. Because I intend to bounce back from this, Your Honor. A lot of people get trapped in the court system and can never move on with their lives. And this time almost got me. But I feel like I still have hope to use some of this potential. And even in jail, a simple battery charge boosts my security level. It puts me around other violent offenders. And it's not the crowd I want to keep, Your Honor. Despite all of this, I believe that I'm better than the past. And given the opportunity to prove it, I may very well surprise you.
We all hope.
That is all. Thank you.
Counsel, requesting any restitution as part of any sentence?
I do not have any documentation filed to provide this for restitution.
Not requesting any restitution. How about other issues that may require probation as a no-contact order?
The no contact order has been in effect, and I would assume that the victim would just want that to continue to be in effect even though he didn't mention it.
Did you want to say something else, Mr. Crowder?
If I may, Your Honor, the only thing that contact order really does is prevent me from installing his boat with the property. As far as, I have no intentions of going around him at all. I presume I could be ordered to not do that through probation. A no contact order, it's a bit rough to deal with on paper. As I said, I am trying to deal with my life. I understand, the court may feel it's necessary, but I have no intentions of going anywhere near him at all.
I understand. Give me a moment.
My concern is just that the no contact order pops up. Let's say I want to go have lunch with my child at school. That prevents that. It does right now, at least.
Well, it's a serious charge, and just can't go around slugging people. Court will accept your guilty plea to the Class A misdemeanor of battery. Again, let me recite my entire sentence before you ask any questions concerning your sentence. Court will sentence you to 180 days in the LaPorte County Jail. Will suspend 172 of those days. Order the defendant to serve 8 days in the Porter County Jail, which I believe has been served with 4 days that were originally served in this case, with good time credit. Looks like you're actually in jail for 4 days. Shows the arrest was on July 3rd and shows bond was posted on July 6th. So if that's not true and you'd rather do the 8 days, I can do that.
I'm fine with that.
Your Honor, in the name of honesty, I didn't do 4 days. I was only in jail from July 3rd, 3 p.m. until July 4th at 1 a.m. So I was only in jail for like 8 hours.
Well, how'd you show up for your initial hearing? Looks like when I saw the docket. Yeah, but your initial hearing was on that day, correct? So you're only in jail a day?
That was a different case.
Okay.
I mean, yeah, I'd love to get the credit, but
Well, I appreciate your honesty.
I try to be honest.
All right. Well, you'll have to serve the 8 days then. It'd be 4 days that would be served if you care to do it straight time. I think
Sorry, what?
you'll have to serve 8 days.
So now I'm going to jail?
Well, I thought you'd already done your jail time, but apparently you hadn't.
Is there a way we can suspend all of that? And if I mess up, I do it all?
Could be, but no. It's my choice.
So I'm doing 8 days?
Well, if you want to do it straight time, you can do 4 days. You get good time credit.
Oh, you mean, I'm sorry, let me let you finish. Weekends, I'm not sure how this...
Well, if you don't want to do it weekends in 48-hour periods, at least over where I come from, you don't get good time credit. You'd have to serve the entire 8 days.
I apologize, Your Honor, I think I might be confused. So I have 180 days and
Most of it's going to be on probation.
172 of it is suspended,
It is.
and you're giving me 8 days for the time that I already did. I'm not going to jail today.
Well, you're not going to jail today no matter what, but if you didn't actually
Okay,
get credit for the 8 days,
That got me confused. And I got
that's why I usually say, let me finish before you ask any questions.
By all means, I apologize.
But you're saying you did not serve those 8 days? Those 4 days?
You know, Your Honor, I don't work for the court, and I'm not really particularly sure. The docket speaks for itself, and these police reports seem to be under penalties of perjury. I'll go ahead and trust the information you have is correct, and go ahead and take your time. I have no objections to that.
Yeah, I would say probably the best thing maybe is that we call the jail and see the actual credit, because I think I was under the same impression you were on that case and the other one, because the other one I know he had a little bit of credit, and I don't think it's reflected in the CCS. And this one, it says he's got credit, but I know he'd made some comment before that he had a hold and that he'd bonded out late that night.
If I may, is it possible that credit's for a different cause number? With all three of these being together, it's kind of got some of it mixed up and overlapped.
It shows up under this cause number. That's all I can tell you.
I have no objections, Your Honor. As I said, docket seems to be correct.
Well, in any event, let me continue with sentencing. Court will impose no fine on this case, but will assess court costs of $185. Place the defendant on a general order of probation for 172 days as a further condition of probation. In fact, rules of probation are incorporated by reference into the court's sentencing order. The defendant shall complete 20 days of community service as well. That would be as a condition of your probation in this
20
case.
days?
20 days of community service. Where I come from, a day is 6 hours. I don't know what it is over here, but it's 6 hours, so that would be 120 hours. My math is right.
I thought it was going to be 24 at first.
Court will grant the state's request for a no-contact order as a condition of probation in this case. You're to have no contact, and that order will be executed. Again, where I come from, we require a signature on that no-contact order, whatever the policies would be of the LaPorte Superior Court, LaPorte Circuit Court. Court will incorporate those policies with regards to execution of the no-contact order. It would be a condition of your probation. This all has to run consecutive to your probation in the companion case. The court is intending to give the defendant credit for the time that has been served on this case. That's what the docket would reflect, and impose credit for 4 days actually served with credit for 8 days. You'll have to make an appointment with probation and sign up for community service as well, I assume, and I'll ask our bailiff and our court staff, probation, direct Mr. Throgmorton to community service.
Actually, entered from the bench, I have a list of providers for community service that I can provide to Mr.
Can we
Throgmorton.
provide that to you? All right.
And quite a number of places that are accepting. But again, under the COVID situation, that might be a extended time to get that done.
Court will entertain, upon probation motion, will entertain any extension of probation if you're unable to complete your community service due to the pandemic.
They're pretty amicable, probation's pretty amicable about that. As long as it gets done and everybody's on the same page.
I should be able to.
Sounds like I'm conversing. I don't mean to converse, but policies are a little different here than where I work, so whatever, probably where Stark County is as well.
And that's why I do have a question. Do I need to prepare the no contact order because I don't have access to your guys' court?
Contact victim advocate.
Victim advocate here will prepare no contact order.
Okay.
I will
Alright.
contact them today.
Okay.
Because then I have to submit it.
And the original no contact order, I believe, covered Mr. Fikes' wife also.
I'm interested in the no contact order versus the victim himself in the case. Will not extend it to another family member.
Okay.
I always deal with the facts as they are, those that are involved. Any further questions on this case? Again, we'll get that order prepared, and you'll have to make an appointment with probation, and we'll be preparing. You have to contact the prosecutor's office, the victim's advocate?
I'll do that.
All right. It's going to be a little bit of work here, Mr. Throgmorton, just so we get it all worked out. I get the impression that you're able to follow that.
Pretty good at walking around here, collecting paperwork and stuff.
What are we going to do with this last case, gentlemen? That's the intimidation case.
Guilty. If we're here, I take a short recess and use the restroom.
It's a good idea.
Appreciate it.
All right.
How about 15 minutes? What time is it?
It is
Just that.
11:04.
15 minutes, and we'll get back in here. Thanks, folks. You can have seats. Let's turn our attention, gentlemen, to our remaining case, which would be 46 DO3 1807 CM 1755. Matter is scheduled today for a bench trial. Been some indication of the court defendant may want to plead guilty to the charge. We'll get to that in a moment. The record will reflect that the state appears by its special deputy prosecuting attorney and defendant appears pro se. And Mr. Throgmorton, again, I don't intend to talk you into something, talk you out of anything. Is it your intention, as you have at least referenced, to plead guilty to the charge in this case?
Yes, sir, Your Honor. I would like to plead guilty to this.
Well, raise your right hand and I will place you under oath. Do you swear or affirm, under the penalty of perjury, the testimony you're about to give will be the truth?
I do.
You put your hand down. Will you state your name?
My name is Christopher Adam Throgmorton.
And Mr. Throgmorton has your address, date of birth, social security number changed in the last 5 minutes?
Not that I'm aware of,
And we'll incorporate those by reference then into the
by all means.
part of our case proceed. And you are the defendant that was charged in this case, correct?
Yes, sir.
All right. Before I accept your guilty plea, allow me to advise you of your rights. Now, as I said, you do not have to plead guilty. You are presumed to be innocent of all charges in all cases. You have the right to be represented by an attorney, which includes having an attorney assigned to represent you at little or no cost if you are indigent. You have the right to a speedy and a public trial by jury. You have the right to confront. Backing up, to reserve your right to a trial by jury for this charge, though, you would have had to file a written demand for a jury trial at least 10 days before your first scheduled trial date. You have the right to confront, question, and cross-examine every witness that may testify against you. You have the right to subpoena witnesses and require witnesses appear in court and testify for you. You have the right to require the state prove you are guilty beyond a reasonable doubt before you can be convicted. You have the right to remain silent, and you have the right to appeal a conviction if you had a trial and were found guilty. Do you understand those rights?
I do.
Sir, by pleading guilty, you are waiving and giving up those rights. Do you understand?
I am.
And is it your intention to plead guilty today?
Yes, sir.
And counsel, would you care to question the defendant so we might establish a factual basis to the charge?
Thank you, Your Honor. Mr. Throgmorton, were you in the county of LaPorte, state of Indiana, on or about the first day of June 2018?
Yes.
Were you in the waiting room outside the mayor's office in City Hall, specifically?
I was waiting there and made everybody uncomfortable. I presume it's a waiting room, so sure. Yes.
Okay. While there, did you engage in an argument with Nicholas Otis?
I don't know if I would. We had verbal exchange, yes.
Okay. And the nature of that argument was about paperwork that you wanted Nicholas Otis to provide you, correct?
You mean the prior lawful act?
Just answer the questions.
Yes, he was, not so much that I wanted him to, I believe that he was ordered by a court to provide them. He felt that he was not, and we had a disagreement about that.
Okay. And Mr. Otis told you that he didn't have the paperwork ready and he wasn't sure whether or not he was going to appeal the order, correct?
Best of my recollection, yes. He said he could appeal it.
Okay. And you wanted him to give you the paperwork right then and there that very second?
I was just under the impression that he had to be honest, because it was a court order from a judge telling him to do something, so I thought he had to.
I understand that, but you demanded you do the paperwork.
I thought that the paperwork meant that he had to, so yes, in my insistence upon right then, I was under the impression that the court order had to.
And because he didn't give you that paperwork, you made various threats against Mr. Otis, trying to place him in fear for not giving you the paperwork.
I said that I would take information about him from one place on the internet and place it somewhere else on the internet. So I believe he feels intimidated by that, and that's all that really matters, from what I can tell.
Your intention was to place him in fear by a threat.
My intent was for him to give me the paperwork, and I guess, I don't know, I was going to do it no matter what, and I had. Like, the information I said I was going to put online, I actually did, and I'm kind of known for doing this throughout the entire county. So,
Let's start with a very simple question, okay? You can explain your rationale for why you did what. We're talking about the factual basis. That's the essential elements for the charge. So, did you threaten him to place him in fear of retaliation for not providing you this paper?
I guess what I did is considered a threat, yes.
Okay. And you would agree with me that you don't dispute the fact that you made various allegations and claims of what you were going to do that would constitute threat.
Yeah, I said I was going to post information about him on Facebook,
Among other things.
among other things.
You said,
Sir, you'll need to speak up for me.
I'm sorry,
you said you were going to ruin his life, right?
Is that a threat? I did say that, but I'm just trying to figure out what's being established as a
Okay.
threat.
You said you were going to ruin his life.
There's a lot of statements. Is there one specifically?
I'm just asking if you make a statement.
Yes, I believe that I said that I was going to make efforts towards making his life difficult on a professional level. Yes.
Did you say the phrase you were going to ruin his life?
I guess I did. The video's not here for sure, yes.
Okay. And did you also say you released personal information about him, including the vehicle identification number and other identifying information about him?
Public records, yes.
Did you also make claims that the police were going to have to kill you if anyone laid hands on you?
I'm under the impression I can defend myself up to my own death, so yes.
Okay. I have no other questions, Your Honor. I was asked that the information and probable cause affidavit be incorporated to establish a prima facie case.
Any objection?
No, I felt intimidated, so apparently I committed an act of intimidation in response. So I have no objections.
My objection was to the admission of the probable cause affidavit and the charging information. My question, I'm sorry.
Video is not on the record, so we're going to go with the police report.
Is that no objection?
No objections, Your
We'll
Honor.
show the probable cause affidavit established admitted to establish a factual basis. You can proceed with the sentencing aspect of this case as well then. Court will accept the defendant's guilty plea to the Class A misdemeanor of intimidation. Do you have a victim for this cause? Do you have a victim impact statement?
I do for Mr. Nicholas Otis, Your Honor.
All right. Would he like to present that personally, or do you have that?
I'm sorry.
You said you had a victim impact statement.
Oh, I'm a witness.
All right. Okay.
Correct.
All right. And sir, you can have a seat right there. And again, as a now victim of this case, you are entitled to make a statement to the court. You're not subject to questioning, cross-examination, or what have you. You may speak freely.
Thank you. This particular incident, the day that Mr. Throckmorton came in response to an order that Judge Alvisos had issued in the Court Circuit regarding a public records request that he had made. Judge Alvisos had ordered the city, not me, the city, to turn over certain police reports to Mr. Throckmorton. When I became the city attorney, so this incident happened in, I think, June of 2018, I became the city attorney, like I testified, in October or November of 2017. When I would get public records requests from him, I would produce certain police reports. And because under Indiana Access to Public Records Act, public police reports are discretionary as the government agency whether you produce those or not. And I had produced them because I didn't think there'd be any big issue with it. until Mr. Throgmorton called one of the witnesses on her cell phone, who happened to be the mayor's assistant, and left a voicemail, and she was very uncomfortable with it. So after speaking with various people at the city, I explained that I believed that we could legally withhold these records from him. We stopped providing those records to Mr. Throgmorton. The judge, Alvisos, ruled against the city. I respectfully think the judge was wrong on that issue, but ultimately it's the client, the city, not Nick Otis, that makes the decision on whether to appeal, file a motion to correct error, or produce those records. I certainly provide legal advice, but it's not my decision at the end of the day. So it's very uncomfortable to have somebody threatening me when really it's not my decision to disclose these records. They're the client's records, the city of LaPorte. And specifically what he said that day was that he brought up my divorce. He brought up my ex-wife and who she was dating. So he'd obviously done enough looking into my life to know who she was now with in a personal instance. And then he specifically said, this is personal. I'm going to ruin you. I'm going to disclose all the reasons why you're getting divorced on, and I'm going to disclose your VIN number, all your personal information. That was very concerning because how somebody gets a VIN number, maybe it's relatively easy, but I certainly don't search out your VIN number, Your Honor. I don't search out the prosecutor's VIN number or Ronnie's VIN number or anybody's VIN number. Like, it's very concerning that maybe he had my social security number. I don't know what he had. But at the end of the day, it wasn't my decision. I certainly provide legal advice to the city, not my decision to give those records to him. It's the city who is the client. So he was putting me in a very difficult position of providing a proper legal advice to my client. So that was very concerning. But it's very concerning for all the reasons that I testified to initially, is that every interaction with him has to be an argument, even when nobody is trying to literally argue with him. In my career, I've been practicing for 12 years. I've been a federal and state public defender. I've sat in small, tiny jail cells with the worst of the worst people, murderers, rapists, child molesters. Mr. Throgmorton's behavior is probably more unnerving towards everybody in the city than any of those people that I spent time with in those jail cells. He harasses women. My assistant, it's very, very inappropriate. I think that, and I'm getting a little off subject here, but what the city government does generally, people can come and voice their concerns at meetings, and problems can be fixed at a local level, and it's a really wonderful thing to see. And he just completely abuses that. He cusses people out. He's called me a fucking retard. He told the former police chief that he's going to prison and he's going to suck the biggest black dick. This is the behavior that we regularly have to interact with him. He's acting nice here today because obviously he wants a limited sentence. But as soon as you don't give him what he wants, he becomes the rudest person I have ever interacted with in my professional experience. And so I believe that the only way to encourage him not to do that, there's ways he can show up and engage in his First Amendment rights, public records requests, without being a terrible human being that he can be when he disagrees with you. I believe that some sort of jail time would be appropriate to discourage this behavior. He's done it. I'm mainly concerned about the women at City Hall. We have women that don't want to serve on committees, commissions, run for elected positions because he intimidates them. And there's no other way around it. Whether he's charged or not, he intimidates them. And it's wrong and inappropriate, Judge. So I know that it's your decision, not my decision, but I hope, and the city hopes, that he receives some jail time for this behavior.
Thank you.
Yeah.
Counsel.
Thank you, Your Honor. Again, I would reference the criminal history that I mentioned earlier in the other sentencing hearings, and I also, I guess, point out the fact at this point, he now has 2 additional prior convictions and things he's already pled guilty to and been sentenced for. And I understand the court giving him leeway based on some of the mitigators that he raised before, but I also still, in spite of the previous decisions in those other cases, do believe he deserves an executed sentence, as Mr. Otis raised. Part of that is just because of the sheer amount of suffering he inflicts on other people to try to get what he wants. And I think this is another situation, like Mr. Otis mentioned, where he's trying to appear a certain way so he gets what he wants. And I would just ask that the court can go and execute sentence, be it in the county jail or be it through some type of community corrections place.
Thank you. Mr. Throgmorton?
Your Honor, I would start out by saying that what you see is what you get. I don't have two personalities, one that I present to the courtroom and one I decide to video record and upload for the entire world to see. They're all the same. I have done a lot of things in pursuit of trying to figure out exactly what happened to my complaint. The public records that I was trying to get, I still have not received. I've pretty much given up on that endeavor. Essentially, the entire 2.5 years that I've been waiting for today has been more of a punishment than jail will ever be. The concerns are that I'm going to... Jail seems to be described as an incentive to stop me from the behavior that I was previously engaged in, and essentially, I will never file another public records request. I'm never going to file anything with the courts ever again based upon this. Like, the whole jail time jail is only going to extend my desire to understand what the legalities of this are. I would like to plead guilty today, go home, and be done with all of this when probation ends, instead of trying to seek out some sort of paperwork that proves the one lie on the part of the government that I can prove, which has caused me to pursue all of this. So, I mean, I understand, Your Honor. I've quite extensively pursued public records and information to be provided to me from my government. And I understand that this makes a lot of people uncomfortable and concerned and whatnot, but me showing up and recording a public official is not a true threat under the Indiana definition of such, and it doesn't meet the muster under Brewington either. Now, I'm willing to plead guilty to this here, but I don't really... I'm concerned if the court is going to take wild accusations with things like intimidating all the women. Like, I'm only charged with intimidating a 6'4" man, but he's testifying that every woman that works for the city or county is intimidated by me, yet there's no legal history of this. It's a lot of conjecture, and I understand that I make people uncomfortable. In my experience, the average citizen is a bother to their government as soon as they want to be involved or ask questions at all. To be perfectly honest, I don't know if a citizen could get information from their government without being an insider or being somewhat overly assertive that they will escalate this to a lawsuit or a protest. Now, as far as the information that I'm accused of threatening Mr. Otis with, this is what I'm known for literally across Northwest Indiana at this point. I'm very good with open source intelligence. How do I get his VIN number? It's on the internet. Do I have a social security number? No. People are a little more protective with that. But if it's on the internet, typically I can find it. My intentions were to make him uncomfortable with this information, but I didn't intend on him to fear for his safety. His reputation, yes. If the information and the statements that I've made were too blurry to be able to define that line between a true threat and a threat against his safety, that is my fault, and I acknowledge that. But this conjecture that, public records requests and cameras and, there's a lot of hearsay that I just intimidate everybody. But there are recourses for this, I'm accused of filing frivolous nonsense paperwork with these public records requests, but there's a process for that as well. I'm told that I crossed the line, and I have a lot of respect for the judicial system. This is literally what raised me. So if this court's going to find me guilty, I have to take that. But as far as my sentencing goes, I would ask this court to avoid sentencing me for his opinions of other people's feelings that sort of he didn't too much testify that I intimidated him, just that that he thought that it could be more information that I would have. He didn't necessarily know. But it's nothing that I have ever posted on the internet came from anywhere but the internet. That's a skill set that I would love to put to a different use somewhere else in the future, but I'm not exactly stupid, Your Honor. Like, I walk that line. Sometimes right on it. But I don't think that it's crossed that line. I'm going to plead guilty here today and say that I crossed that line with Mr. Otis because the court, seems to have all the facts, but I don't want to be given additional weight to crimes that I'm essentially, whether I'm convicted or not. That kind of matters. But unlike Mr. Otis here, Your Honor, whatever order you give me, you're right, I'm wrong. So that's what it's going to be. I would reincorporate the fact that I don't really think that jail is going to help me personally. If anything, that's kind of my problem. Jail is where I was taught that rules are enforced, up to and including by the threat of violence. So, to be perfectly honest, I need some time to just let this go and move on, and I'm not ever going to file anything ever again. This entire situation has broke me of any involvement that I want. The free citizen, this whole theory that my government works for me and I can give them recommendations and critique their behavior. It seems to be a waste of my time and jeopardizing a lot of the more important things in my life. So I'm pretty much done with politics. If I go to jail, probably not. That's what I'm going to sit in there and think about this whole time. It's not a good place for someone like me. There's nothing positive I can do in jail. In fact, I'm a wealth of information. In the jail, I'm probably going to get some innocent people out for nonsense and technicalities. Because we have nothing but time to just go over each other's cases. But, again, I would just reiterate that, being locked inside of a cage is what's wrong with me. It's not what's going to fix me. If I may, I would like to apologize to Mr. Oaks. I had no intentions on making him appear for his safety.
Well, you did.
It was apparently over the line. I accept that. I can tell you that it won't happen again, though. I'm pretty cognizant of what's going on here today and where that line is definitively now. So,
Sir, did you serve, were you originally arrested under this charge and cause number, do you recall?
I'm sorry?
Were you arrested under this case?
Under 1755?
Yes, sir. I show a summons issued to you.
The police report is from, I believe, the 1st or the 2nd.
This is from the 1st of the summons.
Of June, and then I don't end up with a summons until July 6th, the day after the battery charge is filed.
So service was by way of summons, never incarcerated.
Yes, Your Honor, I believe he was actually going to get the summons when the battery occurred.
I was going to get the summons for the trespassing, and then I left and was at City Hall in public records requesting a battery. So, the only reason I was downtown is because I had summons.
Answers that question. Care to be heard, counsel, or further?
No, Your Honor.
Court, as mentioned, accepts the defendant's guilty plea to the Class A misdemeanor of intimidation. Will sentence the defendant as follows. Sir, again, let me recite my entire sentence before you ask any questions about the sentence. Sentence you to 180 days in the LaPorte County Jail, suspend 170 of those days, and sentence the defendant to 10 days in the LaPorte County Jail, which can be served as weekends as a condition of probation in this case, if you prefer.
Sorry, could you say that a little louder?
Beg your pardon?
Could you repeat that a little louder?
I can. It's 10 days in jail. It can be 5 days consecutive, or it can be 5 consecutive weekends. We'll leave it to your preference. and that would be served as a condition of your probation in this case.
All right.
Let me finish. All right. Impose no fine, assess court cost of $185, due as a condition of probation as well. The general rules of probation are incorporated by reference into this court's sentencing order. And are you in need of any form of order of protection or no contact order, Counsel?
No, Your Honor, the jail is not accepting weekend inmates right now, just for the record.
Well, we're making it as a condition of probation, so I'll still allow you the opportunity to serve that as 5 consecutive weekends. There's going to be some flexibility involved with that because of the pandemic, or you could serve it as straight time, 5 consecutive days.
Okay. May I ask a question?
Of course you may.
Is there a time limitation on that? How long do I have to complete that?
I'm going to make that as a condition of your probation.
So just by the time
So you can coordinate yourself with the jail.
All right.
Again, it's a pandemic. There's going to have to be some flexibility. You may show up and they may turn you away because of the
I'm
issue.
aware of that. That's why I was asking. I don't want to create any extra problems for Mr. Boyd. So I'll get a hold of him and figure it out.
And I believe no other issues to address?
No, Your Honor.
Well, I don't generally comment, so I'm not really going to comment here. Except to say, if I don't see you again, I did the right thing. If I see you again, I've done the wrong thing and I'll correct it. So I don't expect to revisit any of these cases again. So hopefully your probation will be your priority, your compliance with the court orders, and we'll go from there. Good luck.
But May, Your Honor, you may see me again, but not in this context. I intend to change the game as far as community gardens and some other things around here. So hopefully it'll be for a much better reason.
Good luck to everyone. Counsel, I believe you're released from your service.
Thank you, Your
All
Honor.
right.